Well, hello. I'm back. Here I am again. Yay! I didn't think I was going to get to do this. Something came up and I'm like, "Ugh." But it all worked out. And I am here to enjoy this evening with all of you. So glad to see you. It's been a day, hasn't it? Some little birdie told me that the prosecution rested today. So we're going to try and get through this and get caught up today and tomorrow. Okay? So, oh, who's with me? Comment, say hello so I know you're there. Welcome. Welcome, welcome. Glad you are here. I have got to look at something real quick. Got to look at something real quick. Oh, gotta go back here. I don't want to hear that. I need to see whom was the last witness. Whom was the last witness? Right now we are watching the Karen Swift murder trial. And let me tell y'all, why am I not seeing comments? I'm not seeing comments. Oh, okay. I need to figure out who the last person is. I apologize. Let's see. Kerry Smith. Okay, Kerry Smith. Who is he? He is the don't want to see that. Kerry Smith is the gentleman who is the to um physical therapist to David Swift, who was charged with killing his wife. We heard of several witnesses today talk about forensics and tire and nails, I mean, the screw, and how it could not have gone in parallel, and the fact that it was screwed in versus a puncture. The reason why was because when you have a puncture, the inside of the tire, inside of the wall, will have a flaring or a mushrooming effect. And it didn't have that. It was a real clean exit. So we're going to go on and go live. We're going to start listening, and I'll tag him. This is the loudest I can get it, y'all.
Yes, sir.
We've talked several times. I'm Daniel Taylor.
Hey, Dan.
Okay.
Hey, love, thanks for joining. I don't know what happened.
When Mr. Swift came to see you, he came to see
I
you
can't pin.
November the 16th of 2011.
I'm not pinning
Yes.
in StreamYard. I'm pinning in
Before he came to
YouTube.
see you, he went to see Dr. Yeo,
Yes.
Y-A-O.
Yes.
And you had the records for Dr. Yeo. You had the records of the referral or some paperwork where he had been referred to you.
That is correct.
And in that, it stated he had been re-injured on 10/25 of 2011.
That is correct.
All right. And that's before October the 30th, 2011.
Yes.
Okay.
No,
And that occurred at his job site, Daenerys.
I can't pin anybody.
And that he, I guess, talked to HR at his job or saw the clinic at his job, and
Yeah.
then they made a referral to Dr. Yeo.
Yes.
Dr. Yeo is a medical doctor.
He is an orthopedics surgeon.
Okay. He's got a lot of experience.
Yes. He was trained at the University of California.
Okay. And his determination of the injury was severe enough to be referred to you.
That is correct.
And it indicated that his injury, what was the term?
A late effect.
Okay. Did that mean that it was torn, the tissue around his knee?
I wouldn't call it a complete tear, but what you would have is a person who had, say, a surgery and an injury, and that injury got aggravated by a sudden forceful motion.
Okay. And that's what the records indicated.
That's what, yes.
And that's why he came to see you.
Yes.
And he filled out for your office this lower extremity functional scale that you went through and asked him to rate himself.
Yes. Yes.
And you reviewed this, I guess, and then you personally examined him.
Yes.
At that point.
Yes, I did.
After you looked at and examined him,
Mhm.
did you find that what he had filled out on his lower extremity functional scale seemed to match what you saw, what you observed?
Well, what I would say is when they fill out a lower extremity functional scale, that is for the patient to express how they're getting along or how they're doing it, at home or whatever. Now, if the question is, do I agree with everyone in what I observed? The answer might be no, but that is from my point of view. I'm not the guy with the painful leg, and I'm not having to go through the things they're going through. So I don't really feel like that scale is, it is for a profile of the patient. It's not to say that, he wasn't like this, or, he was a lot better here.
Right.
Yeah. I'd like to be fair about that.
Okay. But it could be consistent with what you and Dr. Ye observed.
Well, he definitely had limitation and he had pain.
Okay.
That's a fact.
All right.
Mhm.
Just 1 second. You were interviewed back in February of 2018. You listened to the tape earlier. By law enforcement.
Yes, I listened to it. I think that interview was 2019.
Okay, well,
I believe. I will not swear to it, but
you were interviewed before today.
oh, definitely.
Okay.
Yeah.
And you were asked a bunch of questions.
Yes,
And the record, if the record shows February the 1st, 2018, would you?
I would accept it.
All right.
By the way, that would be 7 years later.
Right, but you still had the medical records that you referred to.
Yeah, they had them.
Yes.
They
You-
had them.
And you reviewed that.
And, oh, I definitely reviewed them.
Yes, and you read them, I guess, while they're asking you these questions. Is that
Yes,
correct?
yes, yes.
And didn't you indicate that he would have extreme difficulty walking and lifting that much weight, 125 pounds?
Oh, yes. Yes.
And they asked you the question, just lifting that much and moving, didn't you answer,
Okay.
I don't think it could have been
I
done
can't pin.
in your interview?
As I recall, they asked me, could he have lifted 100 pounds? And I'm talking about just lifting. And I reviewed the record and I said, yes, I think a person with his problem and with his particular strength could have lifted 100 pounds.
Right, but lifting and moving a considerable distance would be extremely difficult.
Oh, a carry, lifting and carrying someone and walking and moving is totally different than a lift with a thrust and like a one-time type movement or even a two-time type movement as far as the energy used, but mainly because of the balance problem.
Okay.
Particularly if you have a bad leg.
But wouldn't you agree it'd be extremely difficult to lift and to carry that much a distance?
Oh, yes,
A person in his condition?
yes.
Okay.
Maybe a step or two, but, not just walk a long distance, no. And will you tell them what else I said there?
You said that it would likely be with more than one individual, is that correct?
That is correct.
Right, but you don't know, that's what, in your opinion, what it would be more likely to do,
That is correct. That was my opinion right there.
just to be completely accurate.
Yes, let's be accurate.
In fact, you told him in order to be done, it would have to involve more than one person to help him carry it.
I would think so.
And you indicated here today that to drag something would take a person in his condition 70 or 75 yards, a considerable amount of time to do, regroup, and to go on.
Yes, I don't think a person in David's condition would have just grabbed someone and drugged them 75 yards and be gone.
I understand.
All right, but
What you think he might have done,
Mhm.
I mean, I'm just asking what, from the medical, what your treatment.
yes,
You said you gave your opinion just then about that.
yes, but again, I don't want to create illusions.
Right.
I just want the truth.
Well, I know, but you weren't there, and you're just talking about your opinion about his condition. You're trying to be honest. You saw him. The doctor saw him before you did,
Yes,
and you've given your opinions about what you think he was capable of or not capable of.
yes,
Okay. And did David Swift continue treatment with you after that date you first saw him?
yes,
And did he continue to come for a period of months after that?
yes, he did.
And while he was doing this, and even before, were you aware that he worked at Daenerys and had a commute and also had family responsibilities?
I was aware of that.
All right. In fact, you talked with him at some points about that.
Yes, I simply talked to him about 2 to 3 times a week, is what had been prescribed. And I felt like if he was going back to work and he was doing, had family responsibilities or whatever, you certainly wouldn't try to force a person to come.
Right. But he was trying to get back to work, wasn't he?
That is the goal.
Yeah. But,
Yes,
and I guess when you see him for therapy after
yes,
this is after his wife is missing. You understand that he has family responsibilities, and was he very regular over a period of time because of all the things he had going on?
I believe that he came when he could.
Okay. You
Yes,
can say that about a lot of patients, I guess.
yes,
And sometimes after a while, would it be true to say a patient might just get to a certain level? It may not be the complete rehabilitation, but they'll just kind of stop coming.
well, yes, a physical therapist or any medical person believes that it should be done just like this. However, if you look at the real world and the patient world, they have a world too. They have responsibilities. They have things they have to do. Now, they do tell us, and we have to either kind of accept it or go, oh, no, absolutely, you have got to be here, or we will have to inform your doctor or that type of thing. And most physical therapists are not going to do that. They're simply going to try to work it out with the patient.
And David Swift continued coming for a period of time.
Yes, he did.
And you observed that, and you observed his injury eventually over time become better.
Yes,
Okay. And when you stopped, I guess when he got to the point that he stopped coming because either insurance didn't pay or because of his responsibilities, that was several months after you saw him for the re-injury.
oh, yes, yes. So we saw him for a long period of time.
Okay.
And I will say this, I may be talking too much, but he always did whatever we asked.
Right. I understand.
There was no static with David.
Finish with the time?
Yes.
Read your Ms. Bob? Yes, sir. Just to be clear, Mr. Smith, when
Yes.
you were talking about something requiring two people to accomplish, you were talking about carrying a 125-pound body?
Carrying a 125-pound body on rough terrain and sometimes maybe with a slope.
And that's opposed to the question I asked you about dragging a 125-pound body.
Well, they're two completely different things.
That's what I thought. Thank you, sir.
You're welcome.
And were you aware that after you saw him for the re-injury that he eventually had to have a second surgery?
Yes, he told me that one day when he came to check on the insurance thing. And he told me that he had been diagnosed with a meniscus tear and that.
Is that in the same leg,
Yes, it was
the
in that
same
leg.
general area?
It was in that leg, yes.
Thank you, sir.
You're welcome.
All right, sir, you are ready to step down. Thank you very much.
Thank you.
Down for the podium, okay? You have a witness we can get in before we take a break?
Yes, sir. I did next week.
Okay. Is that okay?
Mr. Bailiff, can you retrieve
I'm thinking more of myself than I am of you all, frankly.
number 6 right there that's marked for identification?
While they're doing that,
Yes.
what do you think about this, my dear? The Native American headpiece, women. And it's a lot of work. I've got a lot of stuff I got to deal with in the next couple of months. Might as well get it all done at once. I don't have to do it again. Thank you so much for joining me, love. I really appreciate you. You are so, so awesome. You are so awesome, beloved.
Yes, sir. David Howell. Howell? Yes, sir.
Yes, sir.
Sir, you're David Howell.
Yes, sir.
You're a special agent with the Tennessee Bureau of Investigation.
Yes, sir.
And were you an agent back in November of 2011?
Yes, sir, I was.
Did you participate in the execution of a search warrant on 65 Willie Johnson Road in Dyer County, Tennessee?
Yes, sir.
Okay, and were photographs taken during that search?
Yes, sir.
Okay, and how were they recorded?
They're recorded on SD cards.
Okay, and are you in possession of that original SD card?
Yes, sir, I am.
Okay, did you bring it with you today?
Yes, sir.
Okay, you send you several photographs.
So once again, they bring their own evidence. That's strange to me.
Been entered for identification only as Exhibit 6.
I would think that the lawyers would have that ahead of time.
And do you recognize that photograph?
Yes, sir. This came as a result of the search warrant.
Okay, and look at the remainder of the photographs if you will, please. Okay, and do you recognize all of those photographs as being contained on that original SD card in your possession?
Yes, sir.
Have to make those an exhibit to your testimony and move Exhibit 6 from identification into actual evidence, Your Honor.
Okay, Exhibit 6 will now be admitted into evidence.
Okay, and those photographs, did you see a picture of a computer, a laptop computer?
Yes, sir.
Okay, and was that a gateway computer?
Yes, sir.
And did you have any role in securing that as evidence?
Yes, sir. I collected that from the search warrant.
And from your possession, where was it taken?
It was given to the technical service unit, Joel Wade.
Can I interrupt you just a second? Were there additional photographs that were admitted into evidence along with 6?
Yes, along with 6.
Okay, so the additional photographs, Helen, they've been marked as 25? Okay. I'm sorry.
That was fine. I was at the end. Pass it.
Archer, you can step down for you to go. All right, why don't we take about a 10-minute recess for everybody. Remember, don't discuss the case and don't form or express an opinion. All right.
Oh, that means we can't talk about it. We're gonna push through it. We're not gonna wait. We're gonna zoom through the recess. What happened? That's weird. I don't think this person's going to be on the stand very long from what I could see. If you're watching me, thank you very much. I greatly appreciate you. I am your alternate juror. I have been on since 7 o'clock this morning. We ended at about 3. Had a nice little break. I've been very busy with a lot of other things during that break, but we're going to try and zoom.
One jury I had, there was one gentleman on it, and he refused to sit down until I sat down. Everybody else would be sitting down. He said, I'm waiting on you. Thank you all for doing that. You ready to call your next witness?
That was it? That was interesting. It's a woman. Nice thick file.
Yes.
I'm off. Can you hear me now?
Yes.
Okay. And you are a forensic scientist supervisor at the Jackson Crime Lab of the TBI, is that correct?
Yes.
Okay. What kind of education do you have to have that position?
You have to have a bachelor's degree in a natural science or forensic science.
And do you have one of those?
Yes, I have a bachelor's degree in biology and a master's degree in criminal justice.
Okay. Did you join the TBI?
Anybody catch the name?
College, or how long have you been with them?
I've been with TBI 9 years.
I'm turned up all the way.
Yes.
I think he said Smith. Another Smith.
Yes. Yes.
I'm just going to learn Mrs. Smith.
I'm off. Can you hear me now?
Yes.
Okay. And you are a forensic scientist supervisor at the Jackson Crime Lab of the TBI, is that correct?
Yes.
Okay. What kind of education do you have to have that position?
You have to have a bachelor's degree in a natural science or forensic science.
And do you have one of those?
Yes, I have a bachelor's degree in biology and a master's degree in criminal justice.
Okay. Did you join the TBI out of law school, or excuse me, out of college, or how long have you been with them?
I've been with TBI 9 years. I worked for 6.5 years at the Mississippi Crime Lab doing forensic serology. I worked for 10 years at the Arizona Department of Public Safety Crime Laboratory in Phoenix, Arizona. I worked as part of a specialized program that was sponsored by the FBI, and I did a specialized type of DNA testing there for 10 years, and then I moved to Tennessee, and I've been here 9 years doing serology and DNA.
So I'm not really good at math. What's your total number of years being a DNA specialist, so to speak?
More than 25 years.
Okay. And have you testified in court as to DNA findings previously?
I have.
You know about how many times?
Probably all told about 40-ish, and that's in Tennessee and other states.
Okay. And were you accepted as an expert in forensic science?
Yes.
That's from All right, Agent Smith, did you have the occasion previously to examine certain items that were sent to you by the Dyer County Sheriff's Officer, the TBI, in the case of Karen Swift's death?
Yes,
Okay. And do you have your reports with you on those?
I do.
Okay. If you could. Now, first, just so we understand, can you just give the jury, I'm sure most of them have a good idea because of the current state of television, but just a broad overview of what DNA is and when you get an item, how you test it, what you're looking for, and that sort of thing.
Okay. DNA stands for deoxyribonucleic acid. It's the building blocks of what makes us who we are. It codes for things such as eye color and hair color. There's a portion of DNA that we can test in forensic testing, which is part of what I do as my job. When an item of evidence first comes to us, we first look to see if there's any blood, semen, and saliva. Those are categorized as serology type tests. We also can swab and test for touch DNA. If we decide at that point we can go further with our testing, that's when DNA comes into the mix. DNA testing can be performed through a series of tests with the ultimate end, if we're successful in obtaining a DNA profile that we can do comparisons to.
Okay. And I noticed in your report, there are some exhibits that are labeled buccal swabs. Can you tell the jury what a buccal swab is?
A buccal swab is something that looks like a Q-tip swab that's used to swab the inside of a person's cheeks. That is to obtain DNA. And what I would do with that is take that, run it through the series of DNA tests to obtain a known DNA profile. In order to do a comparison of the DNA that we don't know who the donor is, we need a known DNA profile to run so that we can use that to compare to the question or the unknown DNA profile.
Okay. And in this case, I see there's quite a number of buccal swabs, and were those submitted to you by law enforcement?
Yes.
Okay, so you don't know the involvement that person might have in the case. You just know that this is buccal swab from person X. Is that correct?
On the piece of paper that's submitted to us, the kind of line items, what's being submitted, it does identify to us to some degree who those people are, like victim, subject, law enforcement. So I do have an idea.
Okay, let's look at, if you would, your first forensic biology report, which was issued 4/28/20. And for your education, would you tell me what Exhibit 12A is?
Hey,
Well,
Ronnie.
it's a toothbrush from the bathroom of what I have listed as 65 Willie Johnson Road.
Okay, and was a DNA profile previously obtained for that?
Yes.
Okay, and the next one is from Carol Johnson.
Yes.
Okay, and I'm just going to run down the next ones. You received buccal swabs from Deputy Brandon Alexander, Wyman Brassfield, Bill Bona, Kathy Bona, defendant David Swift, John Hogshear, Virgil Wingard, and Alejandro Hernandez.
Correct.
Okay, so those are all, are those all standards that you would have in your system so that if you tested an item and were able to find usable DNA and also put that in your system, that they would match somehow, you would get an alert? Or tell us how that works.
So if buccal swabs are tested, they are put through a very similar process that the question of the unknown, where we don't know the donor of the DNA profile. We would do a series of tests in the laboratory to generate a DNA profile from each one of those. Once you do that, then you can do a side-by-side actual visual comparison. So it is a manual comparison that's done by a person like me versus something that's done in a computerized system at that given point to do those comparisons to say, does this person, are they included or do they match that profile?
And so this was your first involvement in the Karen Swift case, is that correct?
Yes.
Okay, and so the profiles of from the buccal swabs I mentioned, they were previously obtained or developed by another TBI scientist?
Yes.
Okay. Is that something that TBI scientists normally rely on each other? Once a profile is created, it's in your system and you can use it interchangeably?
It can be. I was not at TBI when the buccal swabs were originally tested. When new evidence came in, it came to our Jackson laboratory, and then I kind of stepped in and did the testing from there. I have to look at that point and see if I'm able to develop a profile on the new stuff that I'm testing. Can I use the buccal or the known profiles? And it looked like that I either had the profiles or I had enough of the sample left that I could continue the testing if I needed to at that point.
Okay. Now, going back to that 4/28/20 exam, let's look at Exhibit 63A. So shoes from a dumpster. Okay. Were you able to obtain any information, relevant information from that?
I did obtain information, and I can provide, well, I tested different areas of the shoes, and each one I have listed as a different, or a DNA result, and I can go through each one if you'd like, or talk about specific ones.
Well, let's just cut to the chase, if you would. Were you able to obtain any identifiable DNA from any of these items?
The one area that I was able to do a comparison to was only of quality enough for me to do exclusionary purposes. So I was able to do a comparison on one area of the shoe, which was the left shoe outside sole heel area, and I was able to exclude the DNA profiles, those known profiles, as being a contributor to the profile that I obtained from that particular area of the left shoe.
And that would include basically everyone you had a profile on. Is that correct?
Yes.
Okay. All right. Let's move on to your test of July 31st of 2023 that was issued on July 31st, 2023. You had the same, obviously being a couple years later, you had the same profiles in your system. Is that correct?
I still had the same known profiles available for comparison purposes.
Okay. And in this case, you testified a number of items: a comforter from the dumpster, a dumbbell that was from the 65 Willie Johnson Road, a pair of black rubber boots, a pair of polka dot rubber boots, one roll of plastic sheeting from the dumpster, and one black barber style case. Were you able to test
From a
for determine if there was
dumpster?
any evidence?
I did. I tested
From a
the comforter
dumpster?
for the presence of blood, so that would be characterized as a serology type test, a precursor to DNA. The presumptive chemical testing that I performed on that comforter did not indicate the presence of blood. I also looked at the inside material of the comforter, so I physically cut it open and looked at kind of the stuffing part of it, and visually it did not indicate the presence of blood staining.
Okay. When you tested the middle of the comforter, did you swab that area? How did you test that?
Are you talking about the stuffing?
65A, I'm sorry, going down one.
Okay, 65A is a dumbbell.
Okay, I'm sorry, excuse me. I thought we were still on the comforter. So that's the middle, when you're talking about middle, that's the middle of the dumbbell where the hands would be.
Correct.
Okay, please continue.
I tested the middle of the dumbbell. I swabbed that area. This is where it would, based on the condition of the dumbbell, I decided to go ahead and swab it and just take it straight to DNA. One of the steps where we determine if there's enough DNA to continue on was inconclusive for the presence of human blood. So basically, or excuse me, human DNA. So that tells me at that point in time, there's not enough DNA for me to continue my test, and I don't do anything further. There was also, I tested each end of the dumbbell separately. One of the ends, I swabbed it in a similar manner that I talked about for the middle, and it was inconclusive for the presence of human DNA as well. And then the other end was also swabbed, and it did not indicate the presence of human DNA.
Okay. So let's move on to 66A, which are the black rubber boots that were obtained from a dumpster. Did you find any evidence on those items?
The right boot, I tested the bottom, back half, and top half. What I determined from that is I presumptively tested it for blood, and it was positive. We have another test that we can follow up, and I was not able to perform that test because I didn't have enough sample to do that test and be able to continue on with DNA. So I decided not to do that secondary test and take it straight to DNA at that point. I obtained a limited DNA profile. I was able to tell there was at least one male present, but because it was limited, it was inconclusive to do any kind of comparison. The right front half of the boot, the presumptive chemical testing for blood, it did not indicate the presence of blood, so it was negative. I did not do any testing on the inside of the right boot. For the left boot, presumptive chemical testing indicated the presence of blood. The secondary test, I was not able to perform to determine if it was human blood because there was not very much sample there, so I saved it to do DNA. And when I did do DNA, a limited DNA profile was obtained, and because it was limited, it was inconclusive to do any kind of comparison. The inside of the left boot, I did not do any testing.
And why did you not examine the insides of the boots? Was that at the request of law enforcement?
Typically, when we test the inside of the boot, it's for the wearer or the person that has worn or owns the boots. And what I tested in this particular case, I focused on the outside of the boot for any any blood that may or may not be there, and possibly any touch or transfer DNA.
Okay, and the last three items on the exhibit list are a pair of polka dot rubber boots, plastic sheeting, and a barber-style cape, and no examination was performed on any of those items. Can you tell us why?
I believe, I could check my notes, but my recollection was I talked with the agency, and it was determined that I did not need to test those items.
Okay. Now, the last report that you issued in this case, and perhaps the most important for our case, is the panties from Karen Swift's body that were recovered.
Sorry, daughter
Medical
leaving
examiner's
for the
office.
night.
Did you do an examination of those items? That item?
I did.
Okay, and tell us what you found on those.
So for the underwear, I tested them for the presence of semen. This was a serology test where presumptively I performed a chemical test, and it was negative for the presence of semen. I also presumptively tested them for the presence of blood, and it was also negative. I then swabbed certain areas of the underwear for touch DNA. And that included the sides, the front, the crotch, and the back. I swabbed each one of those areas separately and then ran those through DNA to see if there was any DNA present. For the sides, the testing was inconclusive for the presence of male DNA. For the front, there was no male DNA. For the crotch, there was no male DNA, and for the back, there was no male DNA.
When you say that the on the sides it did not meet the detection threshold, can you explain a little bit further on that? What does that mean? There was some male DNA on there. You didn't have enough of it.
One of the tests, our DNA testing, within the DNA testing procedure, one of the tests that we performed tries to determine how much DNA is present, and it helps us downstream to know if we have a lot of DNA, not enough DNA. And what it told us is that it was inconclusive, which means it was a very, very small amount of DNA that we have determined that if it is not enough for us to go forward with it.
Were you able to determine the type of DNA that it was? Like, was it skin material? Was it blood? Was it saliva? Was it semen?
From my testing, it was the underwear and those areas were negative for blood, but we don't have a specific test for touch or skin DNA, so I couldn't say.
I'm going to hand you your three reports. I just ask you to review them and make sure they are complete and correct.
Yes.
Did you make those an exhibit to your testimony?
Pardon?
Would you make those an exhibit to your testimony?
Yes, I do recognize these three forensic biology reports authored by me, each individually dated with the date that they were issued.
Pass the witness.
Do we need to mark them separately?
I think just a collective is fine, I think.
I believe it's 26.
Judge, I'd like to,
You need these?
if I could, whenever
Yes,
you're
sir.
ready.
No,
Yeah.
go ahead. I didn't mean to hold you up.
I'm sorry. Thank you, sir. Agent, law enforcement determines what to send you based on what they view as relevant to the case.
I would say that they have the option to submit from their case what they choose to.
Right. And so that's what you test.
What is submitted to us is what they are saying line by line that they wish to have tested.
none of these, the testing that you did indicate or implicate David Swift.
I was not able to obtain a DNA profile to do a comparison to that matched or was consistent with David Swift.
And where the items came from, whether they be a dumpster in another state, you're not sure. You're just relying upon law enforcement to send you what they deem important.
Law enforcement did submit items from a dumpster, and if memory serves me correctly, I was aware that they were from a dumpster from another state.
Interesting.
Or do you know?
That I do not know.
Thank you.
Wow.
Making you move a lot. Thank you.
That's a little interesting. Okay, that's interesting, y'all. That's interesting. I don't know how to think or what to think about that. Very interesting. Hopefully we get a name. Oh, get your stuff out. Get all ready. Ooh, you all
I
spiffy.
am. And you're with the Tennessee Bureau of Investigation?
I am.
Can you describe what you do at the Bureau?
I have been employed by the Tennessee Bureau of Investigation since 2000. For the first 12 years of my time at TBI, I was a DNA casework scientist. And since middle 2012, 2013, I moved into our DNA databasing unit, which is where I've been since. This case was actually one of the last ones that I worked while I was a casework scientist.
Okay. And please describe for the jury your education that preceded your employment with TBI.
I have a bachelor's degree in biochemistry. I got that from Auburn University. I also have 2 years of graduate studies at Vanderbilt University in the pharmacology department. I did not actually finish that degree. I left early to pursue a career in forensic science. But that education actually was geared directly for what I did as a casework DNA analyst.
Okay. And have you testified in court before as a DNA analyst?
I have. I've testified across the state of Tennessee over 70 times.
Okay. And were you declared an expert
Yes.
by the courts in those cases in the field of DNA testing?
Yes, I was.
Okay. Okay. Tinder, the witness, is an expert in forensic biology DNA testing. Okay. All right. So I understand that, Agent, you had several occasions to test items in the Karen Swift murder case. Is that correct?
That is correct, yes.
All right. Let's first turn our attention to your report issued 11/4/2011. Do you have that with you?
I do.
Okay. And would you tell the jury, what were you doing there? What were you testing there?
For that report, again dated November the 4th, 2011, there was a 2004 Nissan Murano that was submitted to the laboratory for examination.
Okay. And I see online, it says results 01. Numerous stains labeled A to W were noted on submitted vehicle. Do you know who labeled those stains, A to W?
Those stains were labeled by me. The vehicle was brought to the laboratory, and my supervisor at the time had a conversation with our assistant director to look at the vehicle before it was, I guess, sent to the unit as a whole for testing. And I just happened to be the one who got to test it. So as I examined the outside of it, I would just label stains as I went around it.
You said, are you talking about the outside, or is this the interior?
This is the outside.
Okay. And did you in fact test those stains that you labeled?
So as was mentioned, I had stains that were labeled A to W. I did not actually, testing was not conducted on every stain that was on the outside of the vehicle. Anything that had what we call a reddish brown appearance would be labeled. It's sort of a generic reddish stain. Blood stains can have a reddish brown appearance, so we put a label next to it. I actually tested, sorry, let me back that up again. I actually did test each of those stains with a presumptive color change test for blood. It's something that we call a phenolphthalein test. And for the court reporter, that's PHENOLPHTHALEIN. That test.
Oh, how nice of you.
Blood has a property within it that
That's
will cause
very
the
nice of
chemical
him.
to turn into a pinkish color in the presence of blood.
Thank you.
So all of those
Thank you.
stains.
Oh,
were
wow.
tested,
Thank you, beloved.
And they indicated the presence.
Can
of
you
blood,
make
meaning
sure that
test was
since he
positive.
has a hand?
But only a small subset of those stains were taken for further testing.
Okay. Does phenolphthalein sometimes give false positives?
There can be false positives at times, yes. It's a very sensitive test.
Okay. So did you start testing a certain number of those?
As I mentioned, those A through W all were tested with the chemicals for a chemical color change test. We have additional tests that we can do to look for stains of human origin, and those require a different test.
Okay. Did you perform that different test on any of the stains?
I did. Only stains B, G, O, S, and T were tested. Those were tested for human origin, and they failed to indicate a stain of human origin. Those were tested separately. I collectively tested 3 additional stains, which I had labeled K, I, and L, Those collectively being tested also failed to indicate human origin.
I know it's been a long time, but do you recall why you selected those 8 stains to test as opposed to the others?
I looked through my notes this morning prior to driving here, just so I would be able to refresh my memory why I chose those stains. The stain number B was found on the driver's side door above the handle. Stain G was on the driver's side rear quarter panel near the gas tank. Stain O was the passenger side rear panel above the tail light. Stain S was the rear passenger door above the striping. And stain T was the passenger side door above the handle. So looking at those stains locations and the pictures, I took a sampling around the different locations of the car. And then K, I, and L, the ones I collectively did. One was off the trunk, one was off the bumper, and another was off passenger side high on the rear panel. So if you look at the back of the car, that passenger side quarter panel, it was actually closer to where the trunk lid, the hinge would be, and the top of the window.
So with 8 negative tests, you discontinued further testing.
Yes, after getting negative results on that sampling, I felt that the testing, what I could do at the time was adequate. So the report was issued, and should any further testing have been requested, I would have gone back and done that.
Okay, let's move on to your report from 10/23 of 2013. Where you tested a hammer that was submitted to you.
Sorry, I'm getting all my reports. Yes, it was exhibit number 55-A, listed as a hammer from tool drawer.
And did presumptive tests indicate the presence of blood?
On that one, presumptive tests did not indicate the presence of blood. I indicated in my report that I did swab, take a swabbing from the head and the handle, and those were stored with the evidence, but no further testing was done at that time.
Okay. Now, as I understand, the bulk of your testing was from the inside of the Murano and then other items that were submitted to you.
That's correct, yes.
Okay. And your first one is from, well, actually, there's 3 of them, aren't there? And but some of them contain information, duplicate information.
Yes, I have 3 reports remaining. The first report is from June the 13th, 2012. I have a report from July 9th, 2012 and October 3rd, 2012. The 2 follow-on reports are when additional standards were submitted to the laboratory.
Okay.
And I think one of those also had a couple of additional pieces of evidence.
Okay, because it looks like at first maybe you had John Hogshooter and David Swift were the subjects. And then later on you added some other, I think we heard these names before, Alejandro Hernandez, John Hogshooter, and Swift. And you also added Virgil Wingard.
Yes, sir. Those typically the subject names are going to be added by someone in evidence receiving. So they were follow-on individuals added to the report.
Okay, so let's go through what you found. Let's focus on the Murano, the items that were found in the Murano, and go from there. I think those are contained in Exhibit 1 and then have subsequent letter numbers with that.
Yes.
Okay. Can we go first with 1B, which was a pair of sunglasses from the Murano?
Excuse me. Yes, Exhibit 101-B is listed as sunglasses from the 2004 Nissan Murano. The results that I had for that indicated that I indicated the nose pads and the arms of the sunglasses were swabbed for DNA testing. I got a positive result for human DNA, and reading from the report, a DNA profile was obtained, which is consistent with a mixture of genetic material from 2 individuals. Major contributor is an unidentified female that I listed as female 1. The minor contributor is consistent with the female profile from exhibit number 12-A, which was a toothbrush from bathroom of 65 Willie Johnson Road. And that in turn matched the partial profile obtained from exhibit 48-A tissue that was taken from Karen Swift.
Tissue from Karen Swift, was that obtained from the autopsy of her body?
Yes, sir.
Okay, and so do you have an interpretation of, in layman's terms, what that means as far as minor and major contributor of the sunglasses?
So in layman's terms, on the sunglasses, again, I swabbed the arms and the nose pad. I got a mixture of 2 people on that one. What I call a major contributor was from a female that I don't know who it was. I didn't have a standard to compare to. And the minor contributor is from essentially Karen Swift. To give you a description of what minor and major means, think of a bowl of M&Ms. Everyone likes M&Ms. Most people do. I like M&Ms. As an Auburn graduate, I like to use the colors orange and blue. Forgive me for that. If you have a bowl of blue M&Ms, that is one person. If I take that bowl of M&Ms, let's say it's got 200 M&Ms in it, and I pick up a handful of 50 orange M&Ms and throw it in that same bowl and mix it around some, you can look at that bowl and go, hey, there's 2 colors, but there's a lot more blue than there is orange. The major contributor is the blue. The minor contributor is the orange. So essentially, when I say major and minor, think of that, is that you can easily see there's more of one person's DNA than there is of a second individual.
2 people wore those sunglasses, one more than the other did.
2 people were in contact with that, be it wearing it or handling it with their hands. Yes, 2 people's DNA was on that.
Okay, let's move on to 1C. This is the single-use toothbrush from the 2004 Murano.
My exhibit number 1C, again, I swabbed that one for DNA. I got a limited amount of DNA off that item, meaning I didn't get a lot of DNA is what limited means. The result as I read it is a DNA profile was obtained from this exhibit, which matches the female profile from exhibit number 12A, toothbrush from the bathroom of 65 Willie Johnson Road, which again matches the tissue sample from Karen Swift. I also stated that an additional allele was noted at a specific locus, which is D5S818, and no further interpretation was conducted. So again, think of that bowl of M&Ms, blue ones, and now one orange M&M just got into that bowl. I can't tell you where that orange one came from. I can just tell you that there's an extra allele. There's an extra tiny piece of DNA that was in that.
Okay. Now let's move on to 1E, which is you swap 4 areas of the Nissan Murano: the steering wheel, the gear shift, turn signal, and driver door inside handle. Correct?
Yes, sir.
Okay. Tell us what you found on the steering wheel.
On the steering wheel, again, I found human DNA. And to read from the report, a DNA profile was obtained which is consistent with a mixture of genetic material from at least 2 individuals. Major contributor matches the female profile from Exhibit 12A, toothbrush from the bathroom of 65 Willie Johnson Road, which matches the partial profile obtained from Exhibit 48A, tissue from Karen Swift. The minor contributor has visible alleles at a specific locus, and that is at D3, S1358, FGA, and the gender marker amylogenin. Based on the limited data available, Exhibit 33A, which is Wyman-Brasfield, is consistent with being a potential source for the partial profile of the minor contributor. And then it gives a statistical statement, which I can read if you want me to.
No, that's okay. Moving on to the gear shift, was it a similar type situation for your analysis of the gear shift?
It is similar. In this case, though, I have, well, actually, let me just read the results. I don't want to speak out of turn. A DNA profile was obtained, which is consistent with a mixture of genetic material from at least 3 individuals. None of the following can be excluded as potential contributors to this mixture. And those 3 are Wyman-Brasfield, Exhibit 33A, female profile from Exhibit 1B, the female labeled female number 1, and then also going back to that female profile from Exhibit 12A, which is linked back to Karen Swift.
Okay. So the female who touched the glasses or wore the glasses along with Karen Swift also touched the gear shift.
Correct.
And also, there's been testimony that Wyman-Brasfield was a tow truck driver involved in this vehicle. All right, the turn signal and lights, I think is a little bit different. Can you tell us what you found on the turn signal and lights?
Turn signal lights, that swab. Again, I'll read from the report. A DNA profile was obtained, which is consistent with a mixture of genetic material from at least 2 individuals. The major contributor matches the female profile from Exhibit 12A, which is linked back to Karen Swift. The minor contributor, a male, is visible at loci D3, S1358, and D8, S1179, and is unidentified. This profile does not meet the criteria for submission to the CODIS database for forensic unknown samples. So to explain this one, I got a mixture of 2 people. One, the profile that matches back to what we've used as Karen Swift's standard, and also an unidentified person at 2 locations on the DNA that we test.
Now, you had enough to determine it was male, but not enough to determine who the male was?
That's correct.
Okay, and do you know what kind of material this was on the turn signal that you were testing?
I need to look at my notes. From the pictures in my notes that we took out of the vehicle, it appears to be just sort of a standard plastic cover on the.
Sorry about that.
What I was asking,
The
I'm sorry.
kitten decided to go
Was
crazy.
this a saliva, a blood,
Oh.
a tissue sample that you recovered?
So that sample would have been primarily composed of skin cells. So
Had to
imagine,
kick her out.
Well, I see a lot of us, you and the jury are like me and have glasses, and how many times we handle our glasses. So anything I swab off the sides here are going to be cells that come from my fingertips. If you have a pocket knife, same thing, a pen. Normally I would have a pen if you use a sample. You all have a pen. You could swab that pen with a cotton tip swab, and you're going to be collecting mostly skin cells that are coming off of your fingers and are being mixed with the oils from your fingers. So it's not saliva. It's probably not blood. It's just going to be basic skin cells.
Is there any way of telling how long that DNA sample had been on the turn signal?
We not to my knowledge, there's not a way of dating a sample like that. No.
If it's touched, it could be there until something else touches it or something cleans it, something like that.
Right. So
Correct.
That's exactly right. So if someone gets in the car, handles if you have a car that you drive all the time and you're handling all the gear shifts and the knobs and the steering wheel, and no one ever comes in behind you and I swab it, I should find your DNA profile. If you have a son, a daughter, a friend, a husband, a wife, and they get in the car after you and they drive the car, and I go back and I swab it, I would probably expect to find a mixture of you and them, with them being the minor profile. Now, chances are that they're going to knock some of your cells off. Basically, they're going to mask it with their DNA that they're putting over the top of it. But
Mhm.
it's not just going to fall off. If you don't touch the car again for a year, keep it in a climate-controlled area, not in the sun and the heat and the humidity of Tennessee outside, in your driveway. You should be able to go back a year from now and still swab it and get a DNA profile.
Okay. Let's move on to 1H and 1I, which are both cell phones which were recovered from the Murano.
Yes, 1H is a Verizon cell phone. 1I is an LG cell phone. And on both of those, I swabbed them both for DNA. 1H, the Verizon cell phone, the ear area and the keyboard were swabbed for DNA. Reading from my report, a partial DNA profile was obtained, which is consistent with a mixture of genetic material from at least 2 individuals. The major contributor is an unidentified female, which I labeled as female 2. The minor contributor is visible at locus D3S1358, and due to insufficient or degraded DNA, no further interpretation was conducted as to the source of that minor contributor. 1I, which is the LG cell phone, the back sides and the mat area around the ear speaker were swabbed for DNA analysis. A DNA profile was obtained which matches the female profile, female 1, that was seen in exhibit 01-B.
Okay, so far we have Karen Swift's DNA in the vehicle. We have female 1 and female 2. I was
Correct.
surprised you know that Ms. Swift had 2 daughters that Sanders were not obtained from.
I was actually not aware that she had $2, but it would make sense.
Okay, that's what I was getting at. So let's move on to 2A, 3A, and 3B, which is a jacket that is described as coming from Little Levy Road, pants from Little Levy Road, and belt from Little Levy Road. Were you able to find DNA on any of those?
Exhibit 2A, which was the jacket, I swabbed the collar and the wrists of that exhibit, but reading from the report, tests failed to indicate the presence of human DNA. I attempted to obtain a DNA profile anyway, and no DNA profile was obtained. Exhibit 3A, which was the pants, inside of the waistband, the zipper, and the button were swabbed for DNA. Tests indicated the presence of a limited amount of human DNA, and I obtained a DNA profile from an unidentified female, which I labeled as female 3. I had one locus that was inconclusive due to insufficient or degraded DNA.
Okay, so I'd like to draw your attention to that. So the pants that are described to you as being found from Little Levy Road, this is a new female that you discovered.
Yes, this is a third unidentified female.
And none of this female's DNA was not found in the Murano.
No.
Correct? Okay. All right. Let's move on, if you would, to 21A, 22A, 23A, and 24A, which are all either cell phones or parts of cell phones recovered from the area of the defendant and the victim's home. We'll start with 21A, if you will. Did you find anything on that exhibit? First, tell us what it was, and then did you find anything on that exhibit?
21A is listed as a Motorola cell phone battery for Willie Johnson Road extended, EXTD. That was 21A, and the results, I swabbed that item for DNA, and testing indicated the presence of a limited amount of human DNA. However, no DNA profile was obtained due to insufficient or degraded DNA.
Okay.
22A was a cell phone cover from Harness Road. I also swabbed that item for DNA, and I got no DNA profile due to insufficient or degraded DNA. And 23A is listed as a Verizon cell phone from Harness Road. The outside of the phone and the keyboard area of this phone were swabbed for DNA analysis. The outside of the phone got a limited amount of human DNA. Further analysis resulted in a limited DNA profile with alleles visible only at locus.
There's a lot of a lot of limited.
DNA. No further interpretation of this limited profile was conducted. The keyboard of that phone, again, limited human DNA. However, no DNA profile was obtained from the keyboard.
That's weird.
And lastly, on 24A.
24A is listed as an iPhone from Harness Road. The outside edges of this exhibit were swabbed for DNA analysis. Testing indicated the presence of a limited amount of human DNA. However, no DNA profile was obtained due to insufficient or degraded DNA.
Do you recall testing that item?
Vaguely,
Did you have your notes on that?
I do. That was 24.
The reason I'm asking is your description says you only tested the outside edges. So
Yes.
why you didn't test the front screen of an iPhone?
It could be. If that item was shared with latent fingerprints, then they would have examined part of it. I'd need to see if I did. Oh, okay. The item as I described it in my notes, the packaging contained one cell phone. The front of the phone was broken and fractured, and the back was missing. The outside of the phone was swabbed for DNA.
Okay, so you were not able to extract any DNA from the shattered face of the phone?
I actually did not swab the fractured face of the
Ronnie, have you?
I swabbed around the outside of.
I know
if this is
we're
a cell
done
phone,
with the
this whole face was
prosecution.
just fractured a lot.
How
So
much
I
defense
cut
is
the
going
edges
to
of
put
it that
up?
were least fractured, hoping to catch any DNA that might be present. And honestly, if I'd swabbed over all the broken parts of it, I think it would have just torn the swab more than I could have really swabbed things up.
Okay, thank you. Can we move on to Exhibit 29A, which is a swab from the molding in the living dining room entryway of 65 Willie Johnson Road?
As you indicated, my Exhibit 29A was a swab for molding in the living and dining room entryway, and the results were that presumptive tests indicated the presence of blood. Further testing indicated the presence of a limited amount of human DNA, but no DNA profile was obtained due to insufficient or degraded DNA.
Okay. Now, you did perform an examination on item 30A, which was a pillowcase from the upstairs left bedroom. Do you recall why?
Let me consult my notes on that one also.
Yeah, that's what I'm waiting to hear. What is the nail in the
I
coffin?
don't have any notes on 38 because I didn't examine 38. I do not know why I did not examine that.
Okay, well, there's no evidence to talk about that.
Yes.
On Exhibit 31A, which is a bedpost from the master bedroom at 65 Willie Johnson A, did you examine that?
Yes, the 31A bedpost from the master bedroom. Presumptive tests failed to indicate the presence of blood.
Okay. Let's move on, if we could, to 41A and 42A, which were both swabs from the garage floor of the defendant's home, 65 Willie Johnson Road. What did you find there?
41A, presumptive tests indicated the presence of blood. However, further tests failed to indicate the presence of human DNA. An attempt was made to obtain a DNA profile, but was unsuccessful. Additional testing was then conducted and failed to indicate a stain of human origin. So I conducted 3 different tests, one for blood, one for human origin, and one for DNA. And of those, only the chemical color change test for blood was positive.
Okay. And did that also, same situation occurred in 42A, the other swab from the garage floor?
That is correct. The results were the same on 42A.
Now, have you ever encountered swabs that?
This should have
were
been on the
successfully
Karen
positive for
Reed
blood,
case? What do
how
you
we weren't
mean?
able to obtain DNA from them because they had been cleaned in some manner?
In my years of testing, there were more than a couple of occasions where something would test positive for our color change test that we use looking for blood, but nothing else would come up from it. Cleaning an item could be a reason why that could occur.
The quality of DNA testing?
Positive.
Far better than the Karen Reed. You got
The stain
that
itself,
right.
if it's been
I
cleaned,
figured it out.
what
I'm
area
just
has been
slow
cleaned,
tonight.
the color may still be there, but nothing left in the stain may be present.
Have you ever specifically encountered a stain that was cleaned with bleach?
I have had occasion to work crime scenes that have definitely been cleaned with bleach in the past. And yeah, bleach and blood stains don't go together very well.
I was going to ask, does that interfere with your ability to obtain DNA from a suspected stain?
Bleach is used in the laboratory to actually clean surfaces of contaminating DNA. So
Yeah, that's what I heard.
If something was cleaned with bleach, I'll phrase it this way. If something had been cleaned with bleach, then that definitely would interfere with any downstream testing.
Okay. Let's move on to item 43A, which are swabs from the bottom side rear passenger of the 2004 Murano. Can you tell us what you found there?
43A, sorry, I got lost flipping my pages. Swabs from the bottom side of the rear passenger seat of the Murano. Presumptive tests indicate the presence of blood, and further testing indicated the presence of human DNA. A partial DNA profile was obtained with alleles visible at loci D3S1358, VWA D8S1179, B7S820, TH01, TPOX, CSF1PO, and D16S539. This partial profile is consistent with the female profile, female number 1, which was seen in Exhibit 01B. And can I take this opportunity? Every time I've read out a series of letter number combinations, we have specific areas of the DNA that we look at when we try to obtain a DNA profile. And each of those that I read out represents a specific area of the DNA that I'm looking for. At the time of this testing, we looked at 13 areas of the DNA. So each of those areas would have its specific name, such as VWA or D8S1179. So each time I read one of those, that means it's only that specific area that I see something, or I can only get something from those areas. So 1, 2, 3. So in this case, this partial profile was only visible at 8 of the 13 locations.
How many are required to be considered a match or a partial profile?
Well, partial profile is anything less than the full 13. If I have a partial profile that I'm comparing to a known standard, and even if I have, for instance, 8 of the 13 locations to look at, if I have a full standard to compare with, and each of those 8 matches up, then that's enough. I mean, if it's 5, that could be
I've got a lot of questions for the Karen Reed trial, y'all.
So in this case, we're back to female number one, who was also touching the glasses and touching the gift shop.
That's correct, yes.
Appears to be her blood.
Yes.
Okay. Well, okay, let's go to 44A. No, let's skip 44A and 45A. Let's go to 47A, which is another swabs from the garage floor of Willie Johnson. What did you find in 47A?
For 47A, presumptive tests indicated the presence of blood. However, further tests failed to indicate a stain of human origin. And so my testing would have stopped at that point.
Okay. Am I correct? And that's the end of that report?
That is the only item remaining was just the
Tissue from.
tissue that was used as a partial standard. So
Okay, and can I draw your attention to your, hold on one second. Okay, two more items. Can draw your attention to your July 9th of 2012 report. Okay, do you have that?
I have that,
Okay,
yes.
now Exhibit 50A are the fingernail clippings from the victim, which were obtained from the medical examiner's office. Did you perform a test on those?
Yes, those fingernail clippings were tested for both the presence of blood and for human DNA. And to read the results, the nail clippings from both the right and left hands were submitted under this exhibit number and analyzed separately. For both sets of nail clippings, presumptive tests failed to indicate the
You're
presence
right,
of blood.
Adair.
However,
Nice
further
to
tests
join
indicated
me.
the presence of human DNA. And then on the report, I have a statement that says I attempted DNA at all the locations. And then the results for that are, for both sets of nail clippings, the DNA profile obtained matches the female profile from exhibit number 12A, toothbrush from bathroom of 65 Willie Johnson Road, which matches the partial profile obtained from exhibit 48, tissue from Karen Swift.
So the only DNA associated with the fingernails are the victim herself.
That's correct,
No
yes.
foreign DNA was found.
Only one person. So a bowl of blue M&Ms, and that's it.
Okay. And then the last item I'd like to draw your attention to is in your report of October 3rd, 2012,
Yes.
there was an Exhibit 51A, a small sledgehammer from Harness Road. I think you have to go back a couple pages to get to that. It's on page 4 or 5.
Yes, sir, I've got it.
Okay, could you tell us what your examination of that item was?
So for exhibit 51A, which is listed as a small sledgehammer from Harness Road, the head and the handle were both examined. The submitted exhibit was soiled over most of the surface of both the head and the handle. The head of this sledgehammer, the visual examination of the head and handle failed to reveal areas of staining, and additional presumptive testing of the head failed to indicate the presence of blood. The handle, from a relatively clean area of the handle, a sample was taken for DNA analysis, and tests indicated the presence of a limited amount of human DNA. Due to insufficient or degraded DNA, a partial DNA profile was obtained, which is consistent with a mixture of genetic material from at least 2 individuals. Exhibit 53A, Virgil Wingard, is inconclusive, while exhibit numbers 32A, Deputy Brandon Alexander, 33A, Wyman Brasfield, 34A, Bill Bona, 35A, Kathy Bona, 36A, David Swift, 37A, John Hogshooter, 54A, Alejandro Hernandez, as well as the female profile from exhibit number 1B, which is listed as female 1, the female profile from exhibit 1H, which is female 2, the female profile from exhibit 3, which is female number 3, female profile from exhibit 45A, which is listed as female 4, and the female profile from exhibit 12A, toothbrush from bathroom of 65 Willie Johnson Road, which matches to Karen Swift, can all be excluded as contributors to this mixture profile.
I'd like to hand you your reports if you would, and just make sure that they are correct and complete.
Thank you.
I'm doing a brand new stitch,
sir.
y'all. I think I'm getting the hang of it now,
Sir?
I'd like to move them into evidence.
Nice.
You can make an exhibit to your testimony.
but it looks better.
Exhibit 27.
It's a 2-needle, 2-thread technique.
Mr. Taylor, before you begin, we're going to take a stand up and stick up break.
Stretch, as I used to say to my
Stretch on your
chickens.
way up and stretch on your way down. How you do that, I don't know. But very carefully, I know. All right, we can sit back down. Mr. Taylor can get started.
Yes, sir.
So we're on cross. Sorry about that.
Just a little bit longer. Can I ask you a couple questions?
Yes, sir, please.
The car that was processed, the 2004 Nissan Murano, are you saying it was taken to the TBI lab to be processed?
Yes, sir, that's correct.
So it was transported there. and it was brought to your office in Nashville, or,
Yes, sir. It was brought to the Nashville Crime Lab.
and were you I guess you as an agent decide what to test in the car? You thoroughly go through the car, just different areas, and you take the swabs?
Yeah, when an item like that, a car is brought to the lab, typically, depending on what examinations are requested for that, be it microanalysis, latent fingerprints.
You guys,
DNA,
I can't even
um,
comment in my
will
own chat.
collectively come together. In this case, I know, looking back over my notes, I noticed that not only were there multiple units, but I had multiple scientists from my unit with me. We had 2 new scientists in training that also assisted with that. So you are correct. As we examine the item and inventory it and collect samples, we are deciding as we go what we feel will be the best evidence to collect at that time.
So do you, you look at areas of access that you think will most likely be touched in operation of the vehicle in the driver's seat, passenger area?
Oh, yes, definitely.
Okay. And then you have the entire car, and you go through the trunk, you go through the back seat, you look at the tires, you look at different parts of the car, and you determine what's going to be swabbed or tested.
Yes, we aim to look at every part of the car that we can. We also look at what the statement of facts would be in the case that, there may be items of the car that wouldn't necessarily make sense in that scenario. But we definitely we have an extensive inventory that we create from looking through the car before we start collecting anything.
And if there's a suggestion that the car was used to move a body, you would look at areas where that might be possibly located.
Yeah, ideally, again, based on statement of facts.
The
in
trunk?
In the case, rather, excuse me. We definitely would maybe give closer attention to an area than others. I've had cases where, that's exactly the scenario, is that someone suggested the body was transported in a car. And so we focused a lot on the trunk area at that situation.
Were any samples taken from the trunk area?
Let me look back at the notes. I don't think we did, actually.
Why not?
I don't see anything at the end of the inventory that would. Let me look at our submittal.
Why wouldn't you? Why did you not?
The car was vacuumed. We collected cell phones. There was a tire that was collected from the vehicle. I do not see on here that any swabs were submitted, that we submitted swabs from the trunk area.
And if you had noticed a stain in the trunk area or the passenger area, would you have, your passenger seat, would you have done a test, done a swab?
Oh, certainly.
Yeah. But you don't show any record of any of that being found in this car.
I'm not seeing any additional swabbings of that sort that were on that chain of custody now.
Was any swabbing done of the tire? Did you remove a tire?
I do not recall us removing the tire. I know I did not test the tire, and I do not have any swabs from the tire.
Were all 4 tires on the car when you examined it?
Yes, all 4. There were 4 tires on the car. Yes.
Okay. And was it did they bring it into like a garage where you tested it?
We have we actually have 4 vehicle bays at headquarters lab, so that we're able to examine and inventory vehicles in all weather. So normally what happens is not normally, almost always, a tow truck driver will come in and bring in a vehicle. We'll meet with someone in evidence receiving, and they will, sign off on the chain of custody. That vehicle will then be moved into the vehicle bay so that we can examine it. And I do not recall, and looking at the pictures, I didn't see that vehicle was missing any tires, that all 4 tires were on the vehicle.
Right. And so the vehicle was moved into the bay?
Yes.
Okay. And you examined whatever you thought was relevant?
That's correct, yes.
This process takes hours or days?
It's definitely hours. Sometimes, since we have it at the lab, we can come and go as we need to. I've had vehicles that have taken us a week to process. I don't think that was the case with this one. We probably got it done within a day.
Okay.
Tell me more about the tire.
Just a couple of other things. The
Just
prosecutor asked you
curious.
about bleach and blood, and you indicated that those are no-nos.
Yes, as I mentioned before, that bleach is something that we use when we clean our examination areas. We have a 10% bleach solution that we use first. And we do that because we know that bleach will degrade any potentially contaminating DNA that may be on the surface. So when I say bleach and blood are no-nos, I know that if you have blood stains and you were to use bleach to try to clean it, that is probably the best, one of the better solutions that you could use to try and degrade DNA. And it's just a really good cleaner.
Let me ask you this. If bleach was used on your counter at the lab to clean off blood or DNA, would it Could it eliminate the presence of blood?
That would be, honestly, that would be the goal. If we had a blood stain on the surface that you're wanting to clean it, we're cleaning the surface before we examine something else. So yes, it would, we would eliminate any stains that we see.
All right. Swabs were examined and you testified about from the garage floor near the right door
Yes, sir.
and from the bottom side, well, excuse me, from the garage floor right of Willie Johnson Road.
Yes, sir.
All right. And you did indicate that there was a presence of blood, but you said not of human DNA.
Yes, again, the color change test that we use when we look for blood was positive when I tested those swabs, but there was no human origin.
So are you saying it was possible animal blood?
I am saying that whatever was on those swabs caused the chemicals we use to test for the presence of blood to react positively. It could be blood, it could be something else. I just know that whatever was on that swab reacted positively with the phenolphthalein, but there was no human origin. There's nothing there. Hold just 1 second. I want to make sure I give you the correct wording on this answer. That's a little close. Sorry about that.
Oh, that would be a very good idea, sir.
Presence of human DNA. Yes. So human origin actually and human DNA tests are two separate tests that we can do. In this instance, I did not find anything of human origin or human DNA. But again, whatever was on those swabs caused that chemical color change that we look for when we're testing for blood stains.
Not human.
But that swab came up not human.
Interesting.
Counters at the lab made of.
I couldn't tell you exactly what the material is, but it's a really hard type of epoxy. Actually, they just had to replace a lot of the bench tops in the examination area. Over the years, all of the work and the cleaning, it bleached it out from a nice dark deep green to white.
Is it a porous substance or porous material?
Not terribly porous, no. And it's that way so that things don't soak into it.
Okay. And would cleaning your countertop differ from cleaning concrete?
I would probably clean concrete differently than I cleaned that countertop.
Or
Yes.
is concrete a more porous substance in your countertop?
Oh, yes, definitely.
All right, sir. You can step in. Thank you very much, sir.
Am I released to go back to the national?
Release your witness? Yes, sir.
Thank you, sir.
very much.
I appreciate it.
Today. We have one more witness today. Sure. No.
We're going to go, if y'all are up for
Yeah,
it,
you're
we're
not.
going to go into,
You need a break? Do you mind? Okay, we're going to be in recess for 5 or 10 minutes then.
okay, for y'all who were wondering, what the heck am I doing? I'm doing this. And this is going to look like this. They're going to look like that. Whoop, whoop. I'll be doing a lot of this for y'all. I don't know. I can't even comment. Just FYI, I can comment in my Streamlab, but I cannot comment in my YouTube.
Maybe we'll remember between the two of us. All right.
I'm guessing we're going to get a tire expert now. Y'all, I can't help but talk like this. These are my folk. I was from Bristol, Tennessee.
You are Todd Thayer?
Yes, sir.
Could you spell your last name, please?
It's Thayer.
All right. And Mr. Thayer, where do you work?
I work for the 29th District Attorney General's office out of Dyer in Lake County.
And as part of your duties, were you asked to drive the route from 65 Willie Johnson Road, which was Mr. David and Karen Swift's house, to Bledsoe Cemetery on Harness Road in Dyer County?
Yes, I was.
What route did you take?
Sorry, guys.
Yes, sir.
Would you spell your last name, please?
It's Thayer.
All right. And Mr. Thayer, where do you work?
I work for the 29th District Attorney General's office out of Dyer in Lake County.
And as part of your duties, were you asked to drive the route from 65 Willie Johnson Road, which was Mr. David and Karen Swift's house, to Bledsoe Cemetery on Orange Road in Dyer County?
Yes, I was.
What route did you take to drive that road?
What is he again, y'all?
And drove down Harness Road till I got to Bledsoe Cemetery. Harness Road runs into Bledsoe Cemetery.
And then did you make the drive back?
Then I made the drive back from Bledsoe Cemetery to Millsfield Highway, which is where Miss Swift's vehicle was found.
Okay. And do you recall how long it took you to drive that route?
Roughly 11 and a half minutes.
Okay. And what rate of speed were you driving?
I don't believe I ever got over 40 miles an hour. It's a country road, so if I remember right, I don't think I ever got over 40.
And did you record that drive?
I'm going with it.
Yes, I did.
Okay. And did you bring that video with you today?
Yes, I did.
Okay. And I have a copy to play. And if you would, if you can identify if this is the same video.
Okay.
Is it okay if I start the video and let you identify it, and then we can play it afterwards?
Yeah.
So you recognize this video?
Yes, that's the video. I'm sitting in front of the Swift residence, yes, on Willie Johnson Road.
Okay, so is that the driveway of Mr. and Mrs. Swift?
It is, yes.
And you recorded this drive from the driveway until you completed the route?
Yes.
Your Honor, I'd like to play the video at this time.
Go ahead.
Oh, can we speed this up?
And your beginning time is what?
It is 1:26 p.m. is my beginning time. 1:36 p.m. and it was roughly 30 seconds.
Okay, which road are you on right now?
Right now I'm on Willie Johnson Road, fixing to turn left onto Harness Road. Now I'm on Harness Road.
Where was her car found? Show me. Well, this is Native American stuff. We do gotta go fancy. Because this is for fancy stuff. We have less fancy. This is for a more fancy thing. Anybody out there been to a powwow? Any of my viewers? Been to a real powwow? We love having non-natives at them. People tease me because they say I look more like a Irish woman, and I said because I am. I am more Irish than I am native. I got the Irish skin, the Irish hair. Well, I used to have the Irish hair before cancer. So, thank you. I'll fix it. We gonna skip this, y'all. Okay.
Okay. And as that video ended, were you just arriving at Bledsoe Cemetery?
I was just arriving at the cemetery and the camera I used cuts off after 5 minutes and then starts a new file.
Okay. Is this the second part of that same video?
This is the second part of the same video, yes.
There's a gravel road here. What is that?
That leads to the cemetery.
Okay. I'm gonna stop it here. Is the cemetery straight ahead or to the left?
It's straight ahead.
And the little road there to your left, where does that go?
It goes towards the cross.
And is that the area in which Miss Karen Swift's body was located?
Yes, it is.
And is that the cemetery there on the right?
Yes, it is.
And now as you're backing up here, where are you backing up?
I'm backing up the road that goes to where Miss Swift was found.
Okay, so you backed up into that side road, you said that road goes all the way across to the cross.
Yes.
Okay, and the body was located within how far from that area?
From where I'm at right now, not far from where my vehicle is.
And I don't know if you can see my pointer there. It's, what is that right there that I'm pointing at? The tall thing.
I can't tell if that's the cross or not.
Come on, y'all. That's ridiculous.
Now where are you going?
I'm headed back to drive past the Swift residence and go to Millsfield Highway.
Are you kidding me?
Right.
And is that the same position in the same direction Karen Swift's car was found?
Yes, it is.
Did you make that an exhibit to your testimony?
Yes, I do.
Yep. Kind of in a
Aware of the fact that there was a
odd
ping
place.
originally, I guess, discovered near the Mississippi River when this case first initiated.
Yes.
Okay, and do you know where that ping was?
It was in the area of Little Levy Road.
Okay, and did you have the exact coordinates of that ping?
Yes, we have the exact GPS coordinates.
I'm going to hand you this document, ask if you can recognize that. Oh, I'm sorry. Can you tell me what that is?
This is when you punch in the GPS coordinates in Google Maps, then it drops a pin where those GPS coordinates show up at.
And where did that come from?
From my computer, I did it in the office.
Okay, is that the same document that you have there in your hand?
Yes, it is.
Okay, and there are a bunch of numbers there at the bottom. What are those?
The ones I've got highlighted in the orange is the exact GPS coordinates. And if you look, you see where it pinged at, the red dot in the map itself, right next to the river.
Okay, is this near the Swift home?
It is approximately, it's not near, but it's close. It's a 21-minute drive.
Okay.
Correction, it's a 42-minute drive.
Round trip.
Round trip, yes,
Okay.
round trip.
Okay, are there more than one way to get to that pink area on Little Levy Road?
Yes, when I put in the coordinates and hit, basically give me directions, it gave me three options on how to drive, which direction to go. It gave me three different options.
Okay, would you make that an exhibit to your testimony, please?
Yes.
I'm going to ask if you can identify this next document.
This is one of the three options that it gave me from the Swift residence to the GPS coordinates, and this is the route I took.
Okay, and I'm gonna put that on the screen. If you would tell me if this is the same document that you have there.
Yes, it is.
How many miles was it from the Swift residence to the King on Little Levy Road with this route?
16.3 miles.
Okay, and what was the length of time?
Y'all, I've always wanted to go up in a
21
hot air
minutes and 10
balloon,
seconds.
never
Did you
have.
actually drive that from the Swift?
On my
home?
bucket list.
Yes, I did.
Was that the shortest of the three routes?
In my opinion, yes, it is. This is the most direct route, the route I took.
And it was a 42-minute round trip drive.
Round trip, yes.
Okay, would you make that an exhibit your testimony?
Yes.
Jim. Can you tell me what that document is?
This is one of the other routes that Google Maps gave you an option to take.
Okay, and on that route, how many miles is it?
It's 19.3 miles on this particular route.
And is the map that I have on the screen the same one that you have there?
It is.
And what was the travel distance or time for that one?
25 minutes for this route.
So it'd be what would the total route be for that?
50 minutes.
50 minutes round trip?
50 minutes round trip, yes.
Did you make that an exhibit your testimony?
Yes.
And one more, you said you had, I'm sorry. Yes, sir. You said there were three different routes, is that correct?
Yes, this is a map of the third route that it gave me.
And is the map on the screen the same as the one that you have in your hand?
Yes, it is.
Okay, and what was the distance if you took that third route?
19.3 miles and 22 minutes.
Okay, so round trip,
Round trip, 44 minutes.
did you make that an exhibit your testimony also?
Yes.
And when you took that,
Excuse me, that'd be 32.
yes, sir. And when you took the shortest route, and tell me again, how long did you say it took for that one?
Round trip was 42 minutes.
Okay, what speed did you drive?
I actually kept track of what I drove approximately on each, as I made each turn. Starting at Millsfield Highway, Harness Road to Highway 78, 40 miles an hour and under. When I turned on to Highway 78 and drove to Highway 103, 60 miles an hour and under. Highway 103 to Great River Road, 55 miles an hour and under. Great River Road to Little Levy Road, 65 miles and under. And then arrived at my destination.
All right, thank you.
All right, you sit down, sir.
Oh, that's it?
Any other witnesses today? Well, we made it to Friday. Ladies and gentlemen, again, we're not going to have court tomorrow on Saturday and certainly anything about the case or offers their opinion.
Wow. Yay. Do y'all want to go into the next case? Day 5? I will gladly put us in day 5. I hate advertisements. Guess that was my dog. Okay, let's just get this one going. All righty. Here we go. In the wild blue yonder. Da, 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 da. I'm sorry, I'm trying to get these things right. There we go. And we are on day 5. I want to see if he says
All right,
anything we can hear.
The jury is not present in the courtroom at this time. Mr. Bach, you want to go ahead and call your witness? The court's going to conduct a jury out hearing with respect to portions of the witness's testimony there.
State calls Special Agent Joel Wade.
I can't post anything, y'all. I'll have to figure it out later.
Do you solemnly swear the testimony you're about to give to be the whole truth, whole truth, and nothing but the truth, so help you God? I do. You may be seated.
Is this cross?
Just briefly before we get going, sir, you're Joel Wade, Special Agent for TBI,
Correct.
and I forget what it is now, but it used to be Technical Services Unit.
Now it's the Cybercrime and Digital Evidence Unit.
Okay. But basically, just for the purposes of this brief hearing, you examine, part of your job is you.
I didn't catch that name. I hate this. They should ask them to state and spell their name clearly.
Sir, you're Joel Wade, Special Agent for TBI,
Correct.
and I forget what it is now, but it used to be Technical Services Unit.
Now it's the Cybercrime and Digital Evidence Unit.
Okay. But basically, just for the purposes of this brief hearing, you examine, part of your job is you examine cellular devices and computers and the search to obtain usable evidence off those. Is that correct?
Correct.
Okay. Now, we're going to jump ahead in your testimony for the purpose of this motion. I asked you at one point, you were prepared for me to ask you at one point, did you also look at user named David's internet search history?
Yes.
Okay, and did you discover that the user logged into that account, visited sites that would indicate romantic interests outside of the home?
Oh,
Okay, and tell us what sites these were.
Adult Friend Finder and Match.com. I'll pull those up real quick.
now we got something to be awake about. Somebody's gonna get in trouble.
Most people have no clue that in 2023, the best way to
Oh,
make money on Amazon is not with
somebody's gonna get in trouble. Good night. Nighty, night, nighty, night, nighty, good night. Somebody's gonna get in trouble. As I used to do to my kids. Trouble, trouble, trouble. Coming and knocking. My youngins. I miss that age. Really, really do.
So we have in record 101, chat.adultfriendfinder.com,
What date was that accessed?
11/9/2011.
Did you have any earlier than that?
I have 11/7. For Match.com, it's a thumbnail image. There's another 11/9. Adult Friend Finder. 104 is the record number.
For purposes of the record, the officer from the state line just stating what event number is 104.
Well, there's 280 of these at least. Are we going to go through every single one?
So that's why I'm asking about, relevance also. And when-
200.
I'm not sure I understand the 104 reference. Is that a self-assigned record number?
Yes.
Oh, okay. If you'll just identify the record number there.
So moving down, 105 is Match.com thumbnails. It's 11/7/2011. All these times are still in UTC -6, so they're accurate times, local time for that date. Record number 106, Match.com. It's a thumbnail. It's going to be 11/7/2011, 8:10:44 p.m. Record number 107, it's a Match.com thumbnail image. And it's 11/7/2011, 8:10:44 p.m. Then another Match.com, record number 108, it's a thumbnail. 11/7/2011, 8:10:44 p.m. Record number 109, Match.com, it's an additional thumbnail. Date and time is 11/7/2011, 8:10:44 p.m. Record number 110, Match.com, thumbnail. Timestamp is 11/7/2011, 8:10:44 p.m. Record number 111, Match.com, thumbnail image as well. 11/7/2011, 8:10:44 p.m.
Busted.
Record number 112, Match.com, thumbnail image. 11/7/2011, 8:10:44 p.m. Record 113, Match.com, thumbnails. Timestamp is 11/7/2011, 8:10:44 p.m.
Ladies, always be careful
Record
with
number
what you
114,
post.
Match.com,
Men too.
thumbnails. It's 11/7/2011 at 8:10:44 p.m. Record number 115 is Match.com's thumbnails. Date is 11/7/2011 at 8:02:39 p.m. Record number 116, Match.com's thumbnails image.
Are we going to see what he was looking at?
Date is 11/7/2011, 8:10:44 p.m. Record 117 is to the domain site of Match.com. The date is 11/7/2011 at 7:51 and 26 p.m. Record 118 is Match.com thumbnail. Timestamp is 11/7/2011 at 4:28:07 p.m. Record 119, Match.com thumbnail. 11/7/2011 at 4:28:07 p.m. Record number 120, Match.com thumbnail. 11/7/2011 at 4:28:23 p.m. Record number 121, Match.com thumbnail. 11/4/2011 at 1:14:22 a.m. Record number 122, Match.com thumbnail. 11/7/2011 at 8:10:44 p.m. Record number
So the
123,
moment she was
Match.com thumbnail.
deceased,
Date
Yo.
11/7/2011 at 8:10:44 p.m.
she deceased. She was gone on the
Record number 124,
31st.
Match.com thumbnail.
Oh,
Date
this
and
is
time
bad.
11/7/2011 at 8:10:44 p.m. Record number 125, Match.com thumbnail. 11/7/2011 at 7:53:04 p.m.
Why?
Record number 126, Match.com thumbnail.
Why?
Date is 11/4/2011 at 1:14:40 a.m.
If you loved her,
Record number 127, Match.com thumbnail.
I got to say this. If you love this woman and you were really worried about where she was, your butt would have been searching for her instead of doing the finger search on the computer for matches on these .coms. You knew damn well she was dead. Oh, you disgust me.
11/7/2011 at 4:27:45 p.m. Record number 128, Match.com thumbnail. Date is 11/4/2011 at 1:13:57 a.m. Record number 129, Match.com thumbnail. Date is 11/6/2011 at 10:34:45.
Are you going through
p.m.
all 200 of these?
Record number
I'm speeding
130,
through.
Match.com thumbnail. Number 2011 at 11:30 on thumbnail. 11/6/2011, 10:20 thumbnail.
I hope not.
10:45.
They may not be able to show it.
Record ID 173. Record ID 180 p.m.
Are you kidding me?
Date is 11/7/2000 p.m. Record ID 251. Match.com thumbnail page. All those images get cached during that time period, yes. Record ID 26. Date 11/6/2011, 10/28/31 p.m. Record 270. Match.com thumbnail. Date 11/6/2011, 10/28/31 p.m. Record 271, Match.com thumbnail. Date 11/6/2011, 10/28/31 p.m. Record 272, Match.com thumbnail. Date 11/4/2011, 1:10:42 a.m.
You
Record
disgust
ID
me.
273, Match.com thumbnails. Date 11/4/2011, 1:10:42 a.m.
If it's
Record
one thing if
274,
you're, well, okay,
Match.com thumbnail.
fine.
Date 11/4/2011.
Doesn't matter if you're divorcing. You've
1:14:22
got
a.m.
children at home.
Record 275.
You've got a missing
Match.com
wife,
thumbnail. Date
and you're doing that crap?
11/7/2011, 7:56:40 p.m.
You knew she was gone.
Record 276. Match.com thumbnail. Date 11/4/2011.
Someone who didn't want to get a
7:36:15
divorce.
p.m. Record 277. Match.com thumbnail. Date 11/4/2011, 1:14:40 a.m. Record 278.
God
Match.com
almighty.
thumbnail. Date
How much did you pay for
11/4/2011,
Match?
1:09:50 a.m. And record 279, Match.com domain. Date 11/7/2011, 7:51:26 p.m.
I have a funny story about
All
Match.
of the dating sites that were accessed
Correct.
during the relevant time period.
During that time period, yes.
That's the end of my examination for the purposes of the motion, Your Honor.
Oh, I don't think you need to say anymore.
Related to these records.
Yes, sir. You examined the laptop.
Correct.
This is the laptop from the house.
Correct.
That was the extent of your knowledge of it.
Correct. Yeah, that's all that was on the property receipt as far as where it was located.
The local, I guess, Decatur County Sheriff, Dyer County Sheriff's Department sent it to you for examination.
Incorrect.
How did that work?
It was the VCRT, our Violent Crimes Task Force, was asked to come out and assist in processing the house pursuant to the search warrant that Nation Bishop had issued and got signed. And from there, the Violent Crime Task Force collected evidence and brought that to me.
So
Holy
as a result of the
heck.
search warrant, this laptop was received by that team and the team conveyed it to you.
Correct.
Was it the only laptop in the house?
No.
Okay. And to your knowledge, you don't know what room the laptop was located in? when it
I've
was
never
seized?
seen the house,
Okay.
sir.
And you don't know if it was a common laptop that was used by the people in the house, different users?
The user that was established in this was David, and it was password protected.
Did you establish
Oh.
other users? They're listed.
There was not any other users outside of the local administrative accounts that are built into the operating system.
So it could possibly be a laptop that's being used that other people are using as password. Is that possible?
Oh,
If the password is
that's
shared, it is possible, yes.
oh
And is that sometimes
crap.
common in households? that
That's
there's
the
a laptop-
standard
laptop
excuse
common
that
usage?
everybody
That
in
is possible,
cyber
but
crimes
there again,
use.
This one was password protected and it was changed on 10/24.
1024.
The password was changed. Would you like to see that artifact?
But you don't know if there were other people living in the house that possibly knew the password.
I don't know that, no.
Okay, it's possible though.
Sure, it's possible.
You just know what you see on the site.
I know what account was logged in and what was accessed through that particular account.
Oh
These
my
Match.com
God, y'all.
thumbnails, what's the difference between a thumbnail and just looking on a site?
So all this is in private browsing, which is different than just browsing over the regular domain. So they've made a step to try to protect their browsing history, whoever was viewing it.
Uh-huh.
And so
That's
when you
guilty
load that initial page, all those images get cached.
behavior.
So that's why when I read through a lot of those, it was the similar timestamp because that was when that image was viewed.
Okay, but just from looking at it, if people are sharing a password, it's possible that more than one user had it.
It's possible.
Access to sites.
It's
So are
possible.
you saying his daughters did
If the
it?
divorce occurred October
Oh,
10th,
give me a
2011, what you
break.
have on here is after that date. Are these after October the 10th, 2011?
It starts at October 10th, 2011 and goes to 11/14, which is when we took possession of it.
Okay, so it started the day of October the 10th, 2011.
Correct.
Okay,
Ooh,
and it continued until, what was the last date?
The date that I took possession of it was 11/14/2011, so that's the date that I ran it through.
But the last of these events,
I would have to
yes, if you need to
filter and give you the last date.
the start and the end. So you're saying it,
That was
The
200
earliest was 10/31,
plus.
and I believe the latest was 10/7 without filtering on date.
10/7 or 11/7?
11/7, sorry, sir.
so you're saying 10/31 through 11/7?
Yes, is that date range for these websites.
Okay. What did you say about October the 10th, 2011?
That is that time frame window for the search for this particular work product.
Okay. All right. Now, let me just make sure I'm almost finished. You did a lot of reading and I appreciate that. A thumbnail versus a data, what's the difference?
I don't think I understand your question.
Explain what a thumbnail is.
A thumbnail is a cache version of the image.
Does that mean clicking on it? Or
So as soon as you hit the site, it's going to cache that thumbnail. If you click on it, it's going to cache multiple versions of that image.
okay. Now, you said something about a cookie.
It's a
Cookie is-
small-
so those are artifacts that allow you to go back to that site readily quicker. So it kind of remembers your settings and versus things like that.
Okay.
Most websites use those because they want to target their audience.
Now, let me make sure.
Let me make sure I can't fix this for my client who's a
From
dumbass.
October the 10th, 2011, you talked about, you examined just, these are.
I
all
do not
dating sites.
apologize
That's
for
what you read
saying
on
that
this.
because that's what he
Or
is.
these are all dating sites, what you term as dating sites.
Correct.
Okay. The prosecutor asked you to read all the dating sites, and that's what you just read, right?
Correct.
And you're saying that the access to this dating sites started when? On what date?
10/31 for this time frame. We're only looking at a snapshot of the entire computer. So if we were to look at the totality of the computer, we may find more, we may find none.
All right. Let me just ask, did you look at the time frame from October the 10th until your first event on this?
Correct.
Dating sites?
Correct.
All right. And did you identify any then?
That popped up was 10/31 was that time frame.
The first one? Yes or no?
Yes.
Okay.
Did he say the first
all the
one was
questions I have.
1031?
I don't have any further questions.
Oh.
Chain of custody, Your Honor, Agent David Howell, the TBI testified Friday. We admitted into evidence a picture of the laptop that he personally recovered and had it transported to TSU where it became in the custody of Joel Wade. I believe the serial number from that gateway. So if there's any question about what he examined, that's already been established by the
I
proof.
think the motion to exclude does not encompass the chain of custody.
Okay, I was just making sure.
Yeah. Okay, I'll hear you, Mr.
So this is the little Wi-Fi camera taking the U.S. by storm.
Why am I getting
This
all
brand new-
these? Why am I getting this? Uh-huh.
Present judge or,
I don't think it makes any
okay,
difference.
yes, sir.
In this instance, this is an admissibility question.
I was going to take a break on
Yes,
this
sir.
tonight.
Judge, for the
y'all. I'm
record.
done.
I state my objection for the following reasons. We did file a motion in limine. We did file a motion under 404 and 608. It's been filed several months ago. In addition, we have issues of relevance that we're concerned about. There is some
I bet
computer
you
data
do.
that is on this that we did receive. And this case has been going on for, I guess, since 2022, and I came into it sometime several months after he was indicted. We did receive discovery material. We received these searches. I want to state this for the record because I stated it on May the 14th when we were last in court. And I made the court aware and raised the issue that we had been told that there was forthcoming discovery material in the form of all of these web browser searches. And I informed the court that we had not received these and that we were going to object to it. And we needed time to review this with our expert. And we were informed on May the 14th, the state indicated that they would convey that to me. And we can go back and look at the record. I know Your Honor probably remembers that they would give it to me that day. And we left that day and we asked, and we did finally receive on May the 17th, a downloaded version on some media on a disk. So we had it about 4 p.m. on May the 17th, these web browser searches. That was on May the 17th. And so we've had it during that time. And I made the court, I think, when we first started this case, we started this trial on May the 28th, aware that we had received that and that I needed my expert to look at that. And we have done our best to meet the timeframes and to be ready, but we did receive that. And I object to the admissibility of this so late. And the other thing is these are searches. And I would say this.
He
If you
knows
heard
this
from
is
the questions I
bad.
just asked the agent about,
This is real bad.
is it possible
That's
other
why he's
people
fighting.
use this? And he indicated that it is possible that if they knew the password, it could be. You can imagine a situation, or it could be testimony that other people besides David Swift use this laptop. The
No.
agent just knows what he sees on the search. I would
No.
point out that for
You
relevant
saying his
purposes,
daughter set up the
prejudice
account?
purposes, the divorce was October the 10th, 2011. She filed for divorce. She left for a week. She's gone, but she comes back. They are in the house, but the divorce is still ongoing. She's gone on October the 30th of 2011. It's not apparent that it's a murder. It's not apparent. It could be that she's gone. She just left. And as far as that's the information, you heard the interviews of David Swift. She's gone. I don't know where she is. If there are web searches after that date or before that date, how is that relevant to who killed or things of that nature? It doesn't show anything other than trying to prejudice the jury against Mr. Swift. Now, if there were web searches or browser searches, how to clean up after a murder, how do you kill your wife and get away with it? How do you do this or that promotes some act? And that would be
Goes to
relevant.
motive, my dear.
This is none of that. This is somebody
Goes to
going
motive.
on and looking at dating sites. Now, what does that really prove? What does that really prove? It doesn't prove that he killed her. It's used as to prejudice the jury against him. And to be honest with you, Judge, there's issues of sometimes people are married. Sometimes people look at sites, whether they're married or not. There's obviously some things going on in this marriage that are non-traditional, shall we say, on her part and perhaps. But even if he did look at a web search, even if he did do that, what proof is that he killed her or had a motive to kill her or got some information to further a possible killing? So I object to it. It's speculative. It's being introduced to prejudice Mr. Swift in the eyes of the jury. I would point out that it's possible that other people had access to the computer in the house. And because of the late notice, we also object. 404, 608, other acts. What other act is this? It's not a criminal act. It's not a bad act. It's somebody looking on sites at information. Two people could be married, but they both look at dating sites even though they're married. Does that mean that they killed somebody or that they had a motive to kill somebody? I've seen studies, and we can use our common sense, that people sometimes, even married people, look at sites that are of this nature. And doesn't mean that they had a motive to kill or to do anything. For the reasons, all these reasons I've stated, I object to this. I object to the late notice. I object under 404 and 608. I object to this jury has been here for a while. We need to hear relevant evidence that proves that David Swift committed a murder. That's the burden the state has. This testimony does not do that. It shows that somebody looks at sites. If I'm looking at sites of Civil War sites or something, or if I'm looking at lawyer sites, how does that really prove it? What's the difference with dating sites? She's filed for divorce. She's indicated she doesn't want to reconcile. He's gotten a divorce lawyer, and so before she's gone, and he knows that she's wanting to divorce him. So how is this relevant? Even if he did look, it doesn't mean he did anything to date somebody. It doesn't mean he carried any act, but I submit that it doesn't establish motive. It doesn't establish anything other. It's irrelevant, and I object to it.
The defendant's state of mind is always relevant. And the state's position in this is, no, it doesn't absolutely prove that he killed her. It's very interesting to note that he accepted service of the divorce on October 10th. The visits to the dating sites didn't begin until 24 hours after she went missing.
Okay, well, let's stop right there and take that. For what purpose then are these dating site searches offered? I mean, what's the purpose of it?
The purpose is, Your Honor, the state should be allowed to argue the inference that within 24
that's what I want to know. What is the inference that the state wants the jury to make from this?
The inference is, Your Honor, that within 24 hours of his wife going missing, he is hot and heavy on dating sites.
So
he knows she's not coming back. He didn't get on them when the divorce was first filed. He waited until she was disappeared.
It's the guilty knowledge.
Yes, sir.
Really, you want the jury to infer guilty knowledge from these searches.
Well, and Judge, the jury has heard him tell the investigators, "Oh, I want her to come home. I want her to come home." In both of those interviews, yet at the same time, he's engaged on the October 31st adult friend finder. He's actually chatting with somebody looking for an outside relationship. The jury should be able to hear that he had moved on, that he was not concerned. He was certainly not concerned about his continued relationship with Ms. Swift, and they are entitled to wonder why. Now, as far as the lateness of this, Your Honor, the defense was entitled to examine this computer at any time they wished. All they had to do was file a request. It's going to be just like the state or the defense's tire expert who's going to claim, well, the tire wasn't available for inspection. Well, they never asked for it. So what the defense is actually complaining of, Your Honor, is that we kept
don't ask
probing
for, you
the
don't
evidence
get.
available and found that there was a newer tool that was available that we could extract more information from the evidence that had been. If the defense wanted to examine this item, they could at the time, and their expert would have found the same thing that our expert did. Now, and talk about the burden upon them. We did. As soon as we found out about it, we conveyed that to them. We tried to get it to them. we got this information. At first, it was tried to email to us. It was too large for email, so we had to get a thumb drive overnighted. We tried, again, to email. We tried different ways to email the defense. We had to overnight them a thumb drive. So we did everything we could as soon as it was in our possession to get it to them. We did that. But I submit that ultimately, Your Honor, as far as the lateness of it, it's the defense's own problem because they didn't ask to examine evidence that was available to them.
Yeah, it's up to the attorney to request it.
Okay.
Judge, can I say just one
I think court's ready to rule.
But Judge, for the record, can I say one thing? I would be very.
I'm ready to rule. I don't know what you need. I don't, go ahead. Well, I've heard from you. I've heard from them. Go ahead, though, Mr. Taylor.
And I'm just trying to do my job, Judge.
I understand that, but you only have to do it once.
Yes, sir. I would point out, they said it should be relevant for motive to show guilty mind because he started searching after she left. Speculation.
Slow it down
Because
to
she's
get
filed for
through this.
divorce. Going to reconcile. We've heard that in the proof. She's gone. He didn't know. He told the officers in the interview that the state played, I don't know where she is. I don't know if she ran off. How does that prove that he had knowledge of it? And maybe it was a realization that she's gone and it ain't going to work. And he just starts looking online. So I would just point that out. I think it requires speculation. You're asking the jury to speculate. It is not conclusive that it shows guilty mind. It may show that she moved on. And I appreciate you listening to me, Judge.
Yes, sir.
How to kill all mosquitoes in the area in just minutes. This simple but brilliant trick you can do tonight to eliminate.
This is new to me.
First off, there are other results of the examination of the search or drive of the computer that the state's already agreed it will not attempt to introduce in front of the jury. Is that right?
Yes, Your Honor.
And those would be, and I'll tell you, I can look at the agent's computer screen and see what else is there. Pornography URLs. I assume that's the information that you're not going to attempt to introduce. Okay.
Or be displayed in front of the jury during this.
They should bring that in. That's important.
Both that and anything else that the court may
Y'all,
exclude here.
the judge said the P word 4 seconds after 2 hours.
Is there anything else?
That saved my butt.
That we could make it easier. We don't have to come back and have another jury. Anything more relevant on the computer?
Get on the mic.
Well, certainly there's also going to be testimony that night around 3:30 in the morning, the defendant plugged in an external device to his computer and was viewing a large number of pictures. Now, one of those has already been disclosed from our supplemental report, which the defense has had for years. These two pictures were accessed from an external device.
Pictures of victims.
Whoa. Whoa.
Tattoo.
Yes, sir.
Right, and they were in.
And then also, shortly thereafter, he accessed an external device, which he's unable to tell if it was a digital camera or a cellular telephone. But the state will submit, or the state's going to argue after we see the pictures, that a large number of the pictures on there are of landscaping jobs. And so the state, in closing, will argue that the inference is that was Miss Swift's iPhone that the defendant was accessing at 3:30 in the morning. The photos are all of the children, sporting events. I cannot recall there being a single picture of the defendant on there, but there are, if I remember correctly, 28 pictures of landscaping events. And certainly that is relevant, Your Honor, because if the defendant is accessing the victim's iPhone at 3:30 in the morning when he claims he's asleep, the state should be able to explore that.
Okay, we'll.
I can't
if
show
there's
that
objection to
picture.
Testimony. I think we can take that up as it develops. The defendant has moved to exclude testimony or other proof at trial of the defendant's activities on the internet in the days up to.
What, Ronnie?
I showed the last date. There was one file from November 10. I don't know who that is. That's the one I show as the last time. Anywhere from.
The statistics are 90+% of the men
31
have viewed pornography
November 10,
at
and we're
least once in their
speaking
life.
Specifically at this point about the.
And about 70% of
files that
women.
have been identified thus far as the TBI file number.
I BS
assigned to
you
it,
not.
104 all the way through 279. Those appear to be the matters at issue before the court. So that activity on the internet as revealed by the search there. Although the defendant has expressed some concern about the late production of the search results, court tends to agree with the state here in that the defendant could have made the same examination of the computer files at any point during the pendency of this case. The defendant has not requested a continuance of the case in order to do further research on that. So that's really not the court's problem. In order to determine whether or not this evidence is relevant, though, the court has to first determine whether the evidence has any probative value for the jury. The state asserts that the evidence tends to demonstrate guilty knowledge by the defendant. And assuming for a moment that the evidence has that probative value, the court's got to determine again whether the probative value is substantially outweighed by the danger of unfair prejudice. And if not, whether there is a material issue under 404B other than action in conformity with the character trait or the action, however that denominated. I don't think the evidence is prohibited by 608 at this point because there can't be a credibility attack until the defendant has testified. And so it's not admissible under Rule 608. If there's some material issue under 404B other than the defendant's action in conformity, then again, is the probative value, if there is any, is it outweighed, not substantially outweighed like there is in 403, but is it outweighed by the danger of unfair prejudice? So what is the act or character traits ought to be communicated here by these activities? The state wants to prove that the defendant was looking for a girlfriend within several days, within one day up to almost 2 weeks, not quite 2 weeks, maybe 11 days after the disappearance of the victim, with the logical deduction or the inference that state wants the jury to draw is that the defendant knew that the victim was dead and that he could only know that because he had killed her. That's the inference that the state wants the jury to draw from this information. So it's a bit of a reverse. The state wants to show this activity to demonstrate that the defendant had acted in conformity with getting on Match.com and AdultFriend.com and whatever other sites were represented there to demonstrate that he knew that. 404B prohibits the introduction of a character trait, evidence, or other acts of the defendant in order to demonstrate that he acted in conformity with the trait or the activities. So if the evidence is designed to demonstrate that the defendant must have killed the victim because he was looking for a girl on the internet at the time when, if innocent, he should not have been doing that or could not know that his wife was deceased, then the evidence is required to be excluded because its purpose is to demonstrate that he had acted in conformity with that activity, that he had.
You have reason to believe
that he had killed his wife, and this
that his
shows that he had
knowledge
done that,
of his
that
wife
he-
had been
that his
deceased
actions had conformed
because
with
of his
internet
actions.
Search. One other thing, there may be different explanations for the activity on this end. I don't know what the explanation might be for the pornography sites, and this activity, if correct, may be in extremely poor taste, but it could be that the defendant may have been looking to see if his wife had a profile on the dating site, or if there was another potential suspect who may have contacted her through that site. I don't know, but we're asking the jury to make some guesses here, and we're asking the jury to pick one of, choose a reason for him to be on there. And so because of that, the court thinks that there is the high likelihood of confusion on the jury's part. So references to the activity that is represented by files number 104 through 279 is going to be excluded. And to that degree, the motion is going to be granted there. Are we ready for the jury?
What?
Defendant testify that we're prohibited from cross-examining.
That would change the applicable rules
Yes, sir.
and would
Just
also
making sure
change the court's analysis.
Yes, sir.
Okay, this applies, I'm sorry, to the state's case in chief. Okay? All right, are we ready for the jury?
Oh, gee, gads.
Drinking warm water before bed balances blood sugar levels and reverses type 2.
Y'all, I have never had commercials. Never. Why do I have commercials? What the hell? I don't like this. Not on Law and Crime. I got the new spring boba drink. I have like 40 of these. I'm experiencing interruptions. Most of them I got either with points or somebody gave them to me. Oh, y'all, this just is horrible.
Good morning to all of you. Well, first, I owe you an apology. We've kept you back there for almost an hour and a half. I'm gonna have to take the blame for that. You could have slept another 30, 45 minutes or an hour, and I accept the responsibility for that. I did not make a connection on Friday when we parted that we may have to do this morning without you, so I'm sorry for that. Let me ask all of you first, everybody feeling good? We got everybody here this morning. During anything else connected with the trial, I want everybody to tell me yes or no. Okay. Did anybody give an interview to any media person?
What was that? Sound man, get your act together.
Did anybody do any additional research?
That wasn't me.
Thank you all so much. I appreciate the integrity that you had about this over the weekend. All right, Mr. Box.
State Law Special Agent Joe Webb.
Sir, you have previously been sworn. All right, thank you.
So you are Joel Wade,
Correct.
and you are the Tennessee Bureau of Investigations.
Yes.
And what is your position with the Bureau?
Special Agent,
What unit in the Bureau are you in?
Cybercrime and Digital Evidence Unit.
Thank you all so much. I appreciate the integrity that you had about this over the weekend. All right, Mr. Box.
State Law Special Agent Joe Webb.
Sir, you have previously been sworn. All right, thank you.
So you are Joel Wade,
Correct.
and you are the Tennessee Bureau of Investigations.
Yes.
And what is your position with the Bureau?
Special Agent,
What unit in the Bureau are you in?
Cybercrime and Digital Evidence Unit, previously the Technical Services Unit.
Okay. And what are your duties in this position?
At the time, I was a digital forensics examiner.
Wow, they just
Now
don't
I'm
weird as
currently,
me.
in communications intelligence, where I assist in locating.
Who? Like,
And how long have you been in that?
you said what?
Since 2007. I've been with the Bureau since 2005. Was promoted to Special Agent in 2007 and been in that unit ever since.
Okay. And in layman's terms, what is your job entail?
At that time, we would take in any digital evidence that came in, whether it be a computer, a hard drive, a thumb drive, flash media.
I should have said,
I'm sorry, what?
my favorite.
All right, let's just admit it. That didn't happen.
Second favorite.
They're blowing smoke up my rear end so bad, I'm sending off smoke signals.
I got to figure out what's going on because I see my internet service is good.
2005, was promoted to Special Agent 2007 and been in that unit ever since.
Okay. And in layman's terms, what is your job entail?
At that time, we would take in any digital evidence that came in, whether it be a computer, a hard drive, a thumb drive, flash media from a camera. USB
Y'all, I
drive,
have this sped up 1.5,
DVRs, video cameras, all such things like that, to avoid cell phones.
and you can't tell.
Progressed where we would take in drones, anything that's going to have a digital footprint that a user could create. We have some sort of ability to analyze that.
Okay. And what is your education background, sir?
I have a
I don't know, something's going on, y'all. Hold on. Matt, do you have a problem?
Bachelor's of Science in Psychology with a minor in Sociology from Tennessee Technology University out of Cookeville, and a Master's of Science in Criminal Justice from University of Tennessee at Chattanooga.
Okay, do you have any certifications pertinent to your current position?
I have over 1,800 hours of specialized training in computer analysis, to include CompTIA A+ training, as well as DSTEP and SCRS certified through FLETC. The DSTEP course is the digital evidence acquisition course, so that's where we learn how to take.
Double checked our internet speed, and our internet is working well, so this is on their end.
That piece of media, regardless of whether it's a hard drive or it's a thumb drive.
Thank you guys for watching.
And then the seized evidence recovery program, or SCRS, is where we learn to analyze that, use the tools that we can use to analyze that. Then I have in-depth certification, which is mobile device investigation program through FLETC as well. And that allows us to learn the different operating systems that cell phone we have, from the feature phones that are typically proprietary or a Brew type operating system, all the way to Android and iPhone, and then in this particular case, BlackBerry's proprietary operating system by RAM.
Sir, can I, if you will, please clear your screen? Sure. This screen's on our screen. Thank you.
There's nothing I can do. I am perplexed.
Anyway, I just rather than you understand the technological advances.
I attend conferences. I do peer review article analysis. I am an adjunct professor at Cumberland University in Tennessee, where I developed and teach digital forensics and mobile forensics courses.
Have you previously testified in court as an expert?
I have roughly 17 times.
Here's how auto mechanics remove car scratches in just 90 seconds or less. This simple but
Agent, let me ask you, the 17 times you testified before, has it been Tennessee State Court or other jurisdictions?
All Tennessee State courts.
Has it been in preliminary hearings or circuit court? Or
it's been a variety of those. Some of them have been motion hearings, some of them have been in an actual trial.
And did you attend an actual digital training school?
Yes, I've attended several digital training schools. So FLETC is the Federal Law Enforcement Training Center, where I got those 3 certifications. And then I've been through numerous programs through vendor certifications, as well as tool agnostic programs where we learn ISP, which is in-system programming. We're touching the board with probes to identify different taps, then all the way to chip off forward.
All right, guys, I'm going to keep going because we have a decent following right now. But if you get tired, let me know. We don't have Karen Reed tomorrow. Why am I sound like that? Y'all, am I okay? My sound seems weird. Let me know.
Taking memory chip off of a board to then put it into a reader to read it like we would any other thing.
Right, I understand. Now, the first thing that you said you attended, you used an acronym. I just want to make sure that we all understand.
Yes, so DSTEP is Digital Evidence Acquisition Program, and so that's through the Federal Law Enforcement Training Center in Lincoln, Georgia.
Okay. And did you mention any other acronyms?
SCRS, Seized Evidence Computer.
Okay. If you'll explain it.
Yes, so it's Seized Computer Evidence Recovery Program, and that's where we
go
through.
Is that better?
Once we've acquired it with the tools that we learned in DSTEP or Digital Evidence Acquisition Training Program, we take that knowledge, apply it, and use the tools to create the work products.
Just a couple more questions. The first school you mentioned at the federal, how long was that?
2 weeks.
Okay. The second school that you mentioned, what was the name of it?
Yes, Miss Kevin. And reach out to me in the love.
From a week to 2 weeks, then some are, you take a class for that week, then you continue along where you're working on the evidence, and then you get proctored at the end.
Right. So the FBI would be a 2-week school. The federal school?
The federal school is a 2-week school.
And then the next school is this, you say SCRS?
Correct. It's at the same facility. It's just it's a building block, right? So the first one only allows you to image the evidence, right, to create that forensic image so that there's no changes made to the data. The next allows you to learn the tools and the skill sets and all the scripts to analyze the data.
In addition to those two, have you been to any other schools?
Yes, I've been through FTK. I've been through FTK.
What does that mean?
Forensic Toolkit. It's gone through several different buyouts. External currently owns it. I've been through Magnet.
And how long was that?
Each of it. So that was a series. It was a boot camp series. So I had a whole year to take roughly, 20 plus courses. Okay. So anything from Windows artifacts to registry artifacts, where we're looking specifically at the registry inside the computer.
Okay, I'm almost done.
Sound a little better here than I did in my ears.
Training each year?
I have because of my academic stance, I have to maintain continuing
Oh, it
education
feels
credits.
good to get something other than the hearing aids. These are
Process
softer.
to maintain that as well. There's not a standard in the policy, but anywhere from 40 to 80 hours every year I have attended.
What is your mandatory attendance requirement?
40.
Okay. Thank
State property witness and expert in the fields of mobile device and computer forensics.
Mobile device and computer forensics.
Yes, sir.
Mr. Taylor, you have any objection? We'll accept the witness as an expert in the area of mobile device and computer forensics.
I want to know when he started looking at the naughty photos.
Well, your capacity as a special agent, were you ever asked to examine
This is not a show for children, mind you.
Okay. Did you prepare reports?
You got children, they need to go bye-bye.
Yes, I did.
And did you bring them with you to that?
I did.
Do I still sound that way? I think I sound fine now.
Special Agent Nation Bishop had created
My sounds good in my ears.
Sheriff's Office to assist in investigation. And
That may be the internet.
response team was called out. They deployed, that team collected the evidence at the residence, and from there, Kevin Warren brought that evidence to me on 11/14/2011.
Okay, I popped him to normal. How does it sound?
GBI, or of the GBI for seized items and searches to come into your possession for analysis?
Correct. At that time, there were no digital forensics examiners in Jackson that were fully trained.
Did you
Huh.
examine all the items?
I'm going to speed it up just for play because, you know, here's back up to 150.
They'll provide useful evidence.
Not all of them, no.
Okay, can you tell us why some of them may not have?
Some of the digital camera cards were outside the scope. They were.
Is that
from 2007.
the same or better?
Did not apply to the scope of the investigation. A couple of these cellular phones, the batteries were swollen. So even when I applied power to the device, to a power supply, it was not enough to bring the phone back to life, if you will, in order to examine it.
On Friday, Agent David Howell, are you familiar with Agent Howell?
I am.
Agent Howell testified that during the search of the 65 Willie Johnson Road property, that he personally took possession of a Gateway laptop serial number, and it's very long, but it ends with 91601.
Good, thank you.
And brought it to the Technical Services Unit for processing. Did you perform a forensic examination of that Gateway laptop?
Yes, I did.
Okay, can you describe the process you used to perform that extraction?
So with laptops, typically when they come in this case, when they came in, it was powered off. So we remove the battery from the laptop, then we take off the bottom plate to remove the hard drive from the laptop. Once the hard drive is removed from the laptop, then I place that hard drive behind a piece of hardware that is a write blocker. So what a write blocker does, it allows me to have a stopgap, right? I can read the data, but I can't make changes to the data. When that is plugged up, then I can create a forensic image of that particular hard drive. Once that forensic image is created, then a computer mathematical algorithm number or a hash value is created, kind of like a fingerprint, so that we know that that computer image has not changed. And we verify that image hash value at the end of our analysis.
So can you describe the types of data you obtained from such extraction?
So on laptop computers, obviously you're going to have email, you're going to have pictures, videos, documents. You may have tax documents or privileged information from lawyers or whatever. You also will have internet activity and different things in the registry as far as programs that got installed or removed, various things like that, et cetera.
Okay, after you originally performed analysis of the computer, did you perform another analysis?
I did perform an updated analysis using a newer version of IEF, which had then been rebranded as Axiom.
And what was the purpose of that updated analysis?
To be able to look at the data in its totality. There were more artifacts that were being able to be processed at that time.
Layman's terms, you can see more things?
Correct.
When you were examining this computer, did you focus on a specific time frame?
I did from 10/10/2011 to 11/14/2011, because that's when we took possession of it.
Okay, what's the significance of the 10/10/2011 date as a start?
My understanding is that when Mr. Swift was served with process.
Okay. We've heard previously in the trial, the defendant tell officers he went to sleep on October 30th, 2011, shortly after 2008, slept until around 10 o'clock that morning. Did your examination of the gateway?
You can answer the question.
Can't go? Do this to clear out stuck poop fast. On June 17th in 2019.
I guess it's because I'm streaming it at
I
night.
don't believe it's leading. I think it's set the foundation for the question. So objection be overruled.
Do you mind, can you repeat my question?
Please.
Okay. We heard earlier in the trial, the defendant told officers that he went to sleep shortly after 2:08 a.m. on 10/30/2011, and he slept until around 10 o'clock later that morning. Did your examination of the gateway computer reveal anything that would call the truth of that statement in question?
There were internet searches and activity where devices were plugged into the computer at that time, yes.
Was there anyone logged on to the computer?
The user account David was logged on.
Okay, and can you tell from your examination if logging on to the username David required a password?
It did.
Okay, and were you able to tell what the account logged into was viewing during that time frame?
It had gone to yahoo.com and then immediately started looking at pictures from a removable device.
Okay, when you say removable device, does that have another name? And
So it's digital camera images is the folder structure, but it's going to give it a drive number that's not typically associated with like the operating system drive. It's typically drive C, right? The user can go in and change that, but typically in the install it's drive C. So when you plug anything into the computer, it has to give it a drive letter. It's not going to give it the same drive letter, or otherwise you'd have conflicts, right? So this one is drive letter E. It could have been F, right? But in this it is E.
when you see DCIM folders, are there external devices you typically associate those with?
Digital cameras, right? So it could be a Canon digital camera or a Kodak Easy Share, but it also can be a cell phone because we have digital cameras on our new cell phones.
Were you able to see whether or not the defendant was viewing the images of what appeared to be a female around 313?
Correct.
Okay.
What exhibit are those? Which exhibit are those?
They're not an exhibit yet. I'm just asking if you recognize them.
Yes, I do.
Okay, can you tell us what those are of?
It's a
Have
picture
premium
of,
what?
a tattoo, which would appear on the right side
YouTube? Yes.
of this individual's body. And then it's a second version of that, but the hand placement is different.
Okay. And do you have a time that the defendant was accessing those pictures on the gateway, or the username David, let me be clear, the username David was accessing those pictures?
I do. I need to pull it up to recall them. Was accessed on 10/30/2011 at 3:13:34 a.m.
Okay, is there another one?
The second picture was accessed at 10/30/2011 at 3:13:41 a.m.
Okay, so at 3:13 on October 30th, is that the only time the username David accessed these tattoo goods?
No.
Can you tell us what?
Let me go with that.
Yeah, it cleared. I have premium. I shouldn't be having to deal with that. I don't know. Wait a minute.
UTC, I misspoke. Yes, it is the only time for those instances.
Explain, we're seeing 8:13 a.m. on
So
there.
this report was a supplemental at the request of the Dyer County Sheriff's Office, and at that time I did not convert from UTC to UTC -6.
I normally don't
So it would be UTC
do
-5.
replays.
So what was the local time?
Local time here would have been 3:13:41.
Have you checked the?
Oh, I'm still signed in.
On this?
So then we have 10:30 at 3:13:02. If you'll look back, just so you have the file.
Maybe the
reference,
time of night that we're
following
doing it.
101_1624 and 101_1626. If we look at the weekly history for 101_1626, there was 10:30 at 3:13 in the morning. Then you've got 24 at 10:30, 2011, 3:13, 44 in the morning. Then you have 101_1626, 10:30, 2011, 3:13:02 in the morning. And then
You're so smart.
101_1624 at 10:30, 2011, 3:13:44 in the morning.
Okay, would you make those pictures of your testimony?
Yes.
Being is 33, they haven't been identified. I know we've seen them earlier. I don't think they've been identified yet.
I think at this point, Your Honor, the only identity is they are pictures that were on the gateway signs from the house at 65 Little Johnson.
I thought they were admitted as 19.
No, there are pictures. I would object them being introduced as an exhibit at the time and being used as ID purposes. You can't. There is one earlier. If they're different.
They're two photos.
There is another photo that has been introduced of that same tattoo, Your Honor. These photos are being introduced for the purpose of showing that username David was accessing them at a time he claims to be asleep.
And these are different from number 19.
I think one of them is the same, Your Honor.
Okay. Well, the court will admit the two photographs. That's exhibit 33.
All right, Agent Wade, did the username David access any other photos?
Okay, we're going to switch. Hold on. We're going to do something and see if this solves my problem. I have paid for all of it, but we're gonna switch. I didn't do it, but YouTube did, but my account was switched. I have multiple different accounts and it was switched.
Use, so it would be classified as a smartphone.
And that may have been why I couldn't pin a post.
Were you bringing up the contact, or do you? We'll go over that when we get to the BlackBerry. Okay. The other phone Ms. Clark brought you on November 14, 2011 was an Apple iPhone 4, is that correct?
I hope.
Okay, did you assign an inventory number?
Nope. Maybe. We fixed it.
Inventory item number for that one was 2011-0627.
Okay, were you able to perform?
Y'all are so smart.
No, it was not.
It was under my ADA law counseling account, which I hadn't switched it. I don't know how it got there.
Received was, the screen was cracked. You can tell the frame was a little bit bent.
Freaking finally.
When we tried to remove the printed circuit board, or the logic board in this case for Apple, to put it into a donor phone. So in essence, I would take the board out of that phone and place it into an iPhone that is operable, replacing the logic board so that we could power it on. Upon looking at the logic board underneath a microscope, there's capacitors around the processor chip, and the processor chip itself was cracked.
Okay, were you able to retrieve any useful information from your physical inspection of the phone?
The plate that covers the battery so that the battery stays intact has imprinted on it the serial number of that particular iPhone. From another piece of evidence that was received from the original proceeds of the search warrant at the residence, there was an iTunes backup that identified that same.
Y'all, this is not easy.
So, make sure I'm clear. You obtained a serial number or ID number from the physical iPhone that you found.
Correct.
Okay, and that you were able to look at another, what do you recall what device it was you were looking at?
It was a Dell Dimension desktop, I believe.
Okay, and what information were you able to glean off that computer?
So y'all, what can they bring in if they can't bring in the dating or the adult image sites? What can they bring in if they can't bring that in?
There was an iTunes backup, right? So the phone was physically plugged into that desktop. Apple iTunes was.
I thought all my accounts would be, I mean, all of them would be under, I have one account major and then they all thumbnail, but that's okay. I am not paying 6 times.
iTunes backup. Was there
Yes. Now this little thing that's going is not to do with our internet. I've looked at my computer. I have a kick butt computer and our internet is great. So I don't know where this is coming. It's coming from YouTube.
That is tied to also the imprinted serial number.
Yes, it is worth it to the viewer.
now included the items that were obtained from those.
But this is pissing me off. Oh.
Was there BlackBerry phone? Did you perform an extraction on that device?
Yes, I did.
Okay. And did you assign it an inventory number?
I did.
Okay. Can you tell us what that is?
The BlackBerry phone is 2011-0638A.
Okay, and can you describe the process you used for that extraction?
So similar to what I did on the Voyager.
Well, when you do what I do, it's definitely worth it.
At that time, we removed.
Couldn't live without it.
The battery, checked this, in this case, the BlackBerry is able to have removable storage. There was a 2 gig SD card that was there. We removed that. That's a separate, just like I would do with the computer. I would plug that up through a right rocker, image it, and then combine it with the cell phone. So powered on the BlackBerry, put it in airplane mode, brought it back out of the box, connected it with its USB cable to the software, and then perform the extraction.
Hey,
honey. Identify a principal user of that phone?
Correct. It appeared to be Mr. Swift's work cell phone.
Did he appear to use it solely for business?
There were some communications back and forth with family and the like.
Okay. On the evening of October 29th through the whole day of October 30th, did you determine whether or not this device had any contact with Ms. Swift's iPhone 4 device?
Just want to wake you up.
There were a few call logs and a few text messages.
Okay, now, I understand that you're, and correct me if I'm wrong, let me ask a form of question. How are is the BlackBerry listed on your extraction? I'm seeing the screen right now. Is it all chronological, or do you group things and incoming and outgoing?
It's grouped by incoming and outgoing. In this method, there's not a chronological, or what we would look at now, the bubble look, right, when you can see the blue line and the green going back and forth to see the conversations. So it's at the time the tool allowed to pull that and then put it in the category that it was received in or sent.
Okay, so
Mr. Gunn, we need to take a short break. If I'm not interrupting at a horrible time. Sounds like we're on the front end of a different subject. So let's take about a 10-minute break. Ladies and gentlemen, please remember, don't discuss the case in the jury room. Don't form or express an opinion while we're in recess. Thank you. All
I don't think y'all have seen me with my hair down. It's pretty long. Okay, do you like A or B? I'm trying to find music to play in my stuff.
Gonna take it slow. Take it slow. I'm loving you.
Okay. Now I've had that fun. Now we got the spinning wheel again. What the heck is that?
If we subtract 5.
Oh man, they messed with the mics.
41 minutes and 56 seconds. There's an outgoing call to Karen for 1 minute and 12 seconds.
Okay, when is that next one?
The next one would be at 1:41:42 a.m. On the 30th, 2011 of October for 47 seconds.
Okay,
What is up with this? Unless the server is overloaded.
The next call is 10:30/2011
We're gonna speed this crap up.
at
This wonderful testimony up.
10:28 a.m.
Yes, sir. And the next one?
It is at 11:19:53 a.m. for 35 seconds.
And then when is that next one?
Next one is at 1:31:24 p.m. on 10/30/2011.
Okay, are there any more outgoing calls to Karen?
Okay, guys, I'm gonna skim through all of this.
2:40:05 p.m.
What about the text messages? Were there any text messages during the same time period?
I like the second one better.
Yes, there were.
Can we start with maybe outgoing from the library to the iPhone?
So on 10/30, 2011, this will be actually on the 29th when we subtract.
That's line 82.
82, correct.
Right.
Do you want door left unlocked, comma, how late will you be, question mark, garage doors are down, so use garage, walk indoor, period. Keely is in bed with me upstairs, period.
Okay, and they were just down, they all appear, all the next ones appear to be.
How old was
what's the
Keely at
black
that
scanner?
time?
You tell us the time and the content of the message.
Yes.
I'm not going to be the judge of people co-sleeping with their children. But how old were these kids? Anybody know? I find it very interesting that both parents were sleeping with the kids.
So there again, it's 3 o'clock UTC. We subtract 5 from that, and we're getting still on the 29th. And it's heavy checked on Ashley, question mark.
So that's at 10:52 PM on the
Correct.
29th.
Then the next one is at 10/30, 2011 at 12:26:21 a.m. Are you okay? Question mark. Then the next one is not until 10:26:49 a.m. on the 30th, 2011. Where are you at? Are you bringing breakfast for the girls? Question mark. Then the next text message is 10/30, 2011 at 12:01:58 p.m. Did you have to go back to clean that house more? Question mark, question mark. Then at 12:35:48 p.m. on 10/30, 2011, where are you at, comma, are you with Kathy? Question mark.
Okay, did the defendant make calls to, let's go back to the outbound calls if we can. Okay, let's go to the morning of the 30th, October 30th. Did the defendant make any calls to the iPhone in the morning?
No, we're not.
Can you go back and look up a little bit? See if you can go down too far, go back down to 384, 85. Okay, so let's start on 382. When would that have been?
That is at 10:28:48 a.m. on 10/30, 2011 for 20 seconds.
Okay, and then the next one.
Y'all, I'm going to skim through
10/30,
all of this.
2011 at 1:30. It could have been dialed from that device, but it might have been deleted, or it may not have gone through.
Okay. Just continue down. I'm interested in making after he had called Karen for the last time at 1:30, last time that morning at 1 or early afternoon at 1:31.
He made 2 phone calls to a contact named Preston, 10/30, 2011 at 1:45:39 p.m. for 12 seconds, and then again to Preston at 10/30, 2011 at 1:46:05 for 2 minutes and 16 seconds. Then a call to a contact named Jennifer Lamb, 10/30, 2011 at 2:23 p.m. for 3 minutes and 11 seconds. And then a call to a contact, Kathy Bona, 10/30, 2011 at 2:25:47 p.m. for 4 minutes and 40 seconds. And then shortly thereafter, another phone call to Kathy Bona, 10/30, 2011 at 2:34:36 p.m. for 4 seconds. 10/30 call phone.
Y'all, we've already heard some of this.
442-9451.
Yes, it's listed as Jamie with a Y.
Are you guys okay with me skimming that up? I think we've heard a lot of this in the voir dire.
It's incoming first.
So. To the
So that was an outgoing call to the Jamie contact with a Y at 10/30, 2011 at 5:28:27 p.m. for 1 minute and 8 seconds.
Okay, are there any more? 30th?
Then another phone call on 10/30, 2011 at 4:12:56 p.m. for 33 seconds.
Okay, and this phone number that David's phone is listed as Jamie, is that the same phone, the Voyager phone call on 10/27?
I believe so.
The Verizon records.
Well, the 2 youngest.
442-9451 Jamie number in Karen's iPhone?
I don't believe so.
Would you make reports on the examinations and extractions you performed, included your testimony?
Yes.
You brought that on a thumb drive?
Correct, it is.
And that encompasses everything that you've done.
Every work product in this case.
I mean, admitted it's exhibit 34.
I don't know. I got too much here to look through tonight. Just have too much to look through here tonight.
Agent, let me ask you just a few questions. You received the laptop that you, the gateway computer laptop that you were testifying about as a result of the search of David Swift's house.
Correct.
That occurred November 14th of 2011.
I received it November 14, 2011.
Thank you for correcting me. You examined it.
Yes, sir.
You weren't there when they did the search, were you?
No, I was not part of the violent crime task force.
You don't know exactly where in the house the laptop was located, do you?
I can read the evidence logs and tell you, but I was not present there, no, sir.
And you testified also, I'm thinking about it, about some other cell phones and electronics that you examined in this case.
Correct.
You mentioned a cell phone with swollen batteries.
Yes.
Some of these could have possibly been old phones that were on the scene.
Yes.
No, the one that was swollen, you testified about swollen batteries, you couldn't extract any information.
Not at that time, no, sir.
It's fairly common for people to keep old electronics sometimes.
Absolutely.
And you just examine whatever
But
they
the boys were gone. It's the two girls that were
Gateway
young and home.
laptop, you indicated that there was a logon for David Swift.
Correct.
Now,
Well, it was the logon for David. There was not a last name associated with it.
was there a logon for others?
There was not any other local account, no.
If that was a laptop that was being used by several people in the house, is it possible that they had others, if they used it, had David Swift's logon password or logon?
It's possible.
Now, when you say logon, is that, this is 2011, is this just like a short code?
It could be digits, it could be a passphrase.
And if I, for example, if I share my logon with others in the house, then they can just click on it, put that in, and then have access to anything under my username.
Correct.
And you don't know whether or not that was done or not done in this case, do you?
No, I do not.
So if there have been another person in the house or children that came from time to time, it's possible they shared this logon information when they were at the house using the computer.
That's possible.
You're processing the information you received to see what it shows.
Correct.
Now, the report that you did fairly recently is it the Axiom?
Axiom is a product of Magnet, yes.
Was that done pretty fairly recently?
Within this year, yes, sir.
Not in 2011. I guess that program wasn't there then.
It was so the program in 2011 was Internet Evidence
Whoa.
Finder, by the same company. Internet Evidence Finder was a precursor to what now is Axiom, which is what they have branded the forensic suite.
And you use that as far as.
Hello.
names of the
Thanks for joining us again.
Is there a conversion that's involved to figure out, you indicated a 5 or 6 hour window? Is there a conversion ratio?
So all dates are stored in UTC. And so at this time frame in 2011, we were in this area where this laptop and device was located was -5.
Now, -5, what does that mean?
So we take at the prime meridian, right, in Greenwich and all that, that's absolutely 0 time. So then we subtract back 5 hours and we get to Central Time in this part of Tennessee.
In October the 30th of 2011, what are you saying the time was?
It would have been 5 hours behind what absolute time was.
And would that change, like, this is at the end of October, and you've heard of daylight savings time?
It would have changed later on in November.
You know the date it changed?
I would have to look it up. I don't recall.
And how would that affect it? Would it
It
fall
would
back?
move it back 1 more hour.
So it would be the fall we fall back.
Correct.
And on October the 30th of 2011, you believe the time was not, you believe it was on daylight savings time?
Correct.
Now, if I could. If I could pass this to the witness.
Are y'all hearing any sound effects?
Sir, I'm going to hand you a calendar from November of 2011. Would you look on the date of November the 6th?
That's when daylight savings is marked, yes.
Now, what?
The tool takes into account that date, so it's going to be -6, but if it's prior to that, it would show up as -5.
So, but were you computing it as -6 or -5?
When I was reading the UTC times and one of the evidences, I was computing it as -5. When I did that extraction, it was already set to daylight savings because it's a checkbox that we can check to have daylight savings enacted, so it knows where the calendar is without reading the calendar.
But daylight savings time, would make it an hour earlier, would be November the 6th of 2011.
Correct. That's when, in this year, based on what you're showing me, would be in November 6th. What I'm telling you is the tool takes into account daylight savings regardless of when that is. So it calculates that timestamp. If it's showing -6, that's the standard for Central Time for this region of Tennessee.
So it's going to either be -6 or -5.
Ada.
Based on say
Ada.
-6 or -5, the time still would have been the time.
Did you personally check it yourself?
A lot of people call me Ada. And it's like, nope, Ada,
Remember the 6th,
Ida,
2011 when daylight saving time?
Ada, Ida,
That would have made it
Ada,
a 5-hour.
Ada.
A 5-hour conversion. No, or would it?
Would be
It's
6 hours.
a biblical
Prior
name.
to that, it would be -5.
Thanks for asking.
And you did review that in daylight savings time. You're satisfied on this calendar as November the 6th of 2011.
Based on what you're showing, yes.
Judge, I would just ask that judicial notice be taken of that date on the calendar. I showed it to the prosecutor. I can pass it up to the court.
Do you disagree with that as well?
No objection, we looked into it, that is exactly the same.
I guess that'd be made into the.
I can't hear him. Now all I get in my ears is like air conditioning noise. And I don't have my fan on. Add air? ADD, add air? Add air. Like it. Thank you, Mr.
And the times. And you indicated, I guess through this relevant period, that you showed activity on October the 30th at 3:13 a.m. through 3:30, 41 seconds. Would that be correct?
I believe that's roughly the time range of the pictures we showed, yes.
And so, to be honest, you can show somebody used that laptop to have some activity with the pictures.
Correct. Somebody had to physically plug in a thumb drive to view those pictures.
Now, it had to be somebody that used the, I guess, the login or logged into that laptop.
Correct. There's a, and we didn't go over it, but at 2 o'clock, well, like 2:46, there is a log on of that account on there.
And so if people were at the house, whoever logged onto it could have downloaded these pictures. Should you just say somebody that logged on, whether it be Mrs. Swift or David?
I can say who, I can just say that user account was used to access those images.
Now, the images were largely family pictures that you indicated were being downloaded to the computer.
Viewed, not necessarily downloaded.
And there's nothing about, that you can tell which individual other than the person that logged onto that laptop viewed those images, can you?
I don't know who viewed them. All I know is that account was accessed to use to view those images.
And a lot of them are family pictures and things of that nature.
Correct.
But you can say that at that time, whoever logged in during that period from 3:13 to 3:30:41, you don't know where the laptop was either in David Swift's bedroom or either downstairs in the living room, do you?
I have no knowledge of that, no, sir.
And it could be that someone woke up and looked at images or had this activity.
Somebody was on that device at that time. I don't know if they woke up or they were already up.
Or somebody arrived from a party and was interested in accessing images.
That's possible.
Were any photos downloaded?
There might have been some photos downloaded. We would have to go back and look directly for that.
And if a photo is going to be downloaded, would that be from a certain device, like a phone or a camera?
Or the internet, yes. Could have been from either, all three of those.
Can you tell who was downloading, what device was downloading or not?
I can tell them
Hey, Miss Ronnie.
the original image. I can't, outside of that, there's not any way to tell who was connecting it or.
Whether it was Mrs. Swift or Mr. Swift.
Okay, Miss Ronnie, what is your full name?
Now, whoever, if I take a picture and I send it to one of my family members, they'll have that image. And when they download it, if they choose to download it like in this manner, will it show that it originated from my phone?
Well, that depends. It will have certain metadata artifacts that will attribute to the aperture, the frame rate, all that of that particular picture. And it may
He's
show
talking, I'm sorry, he's talking about metadata.
on another piece of media.
Y'all,
It's a new
metadata.
new access to the modified date. It'll have the modified date as the created date of the original image.
Metadata.
Photo I take it and they choose to download it, would it look like it was originated from them?
Potentially, it could look like it was originated from them, depending on what is left in the metadata.
Oh, there it is.
Now, I guess the time frame you're talking about on the laptop from 3:13 through 3:30:41, it does indicate that whoever accessed it was home, was with the laptop wherever the laptop was.
Was with the laptop wherever it was. Yes, I don't know if they're home or in the backyard or where.
Right. It would indicate that they're with wherever the laptop is. If the laptop's in the home, then they're in the home looking at the laptop.
Correct.
Either in a bedroom or in a common area.
Correct.
Okay. The 1577 is David Swift's phone number, iPhone.
I don't have an iPhone in this
I
case.
mean, excuse me, BlackBerry on this phone.
I believe the last four are correct, yes.
And the prosecutor asked you about my client's, Mr. David Swift's, his phone contacting or trying to contact the phone, the iPhone of Karen Swift.
Correct.
The records you testified indicate that he did try to communicate with her on October the 29th.
Correct, yeah, it was early hours, yes.
Oh, that's a pretty name. One of my good friends in college was Miss Veronica.
I'd have to go back and look, but I believe there was communication through text and calls, if that was what it shows.
And indicated that there was an issue with his daughter.
I don't know if there was an issue, just asked if he had checked on a particular daughter.
Okay, that's fair. And then at some point,
Y'all, I have to let you in on a secret. New information in the Karen Reed trial. Defense attorney Alan Jackson anticipates this case will only take approximately 4 days. The trial is hoped to end before July. Also, will Trooper Michael Proctor testify? Jackson doesn't know. Ah, cliffhanger. Sorry.
that stops. And then the next morning, the prosecutor asked you, you indicated that there were calls from David Swift's cell phone in trying to contact his wife or ask her questions.
I don't believe there were calls, I believe there were text messages, him trying to reach out.
There's contact.
Correct.
And there's several attempts at it.
Yes.
And there's no response.
Correct.
The prosecutor asked you some questions about Mrs. Swift's phone calls, I guess, to somebody else on the night of the evening of 10/29/11.
Yes.
Was that from the Voyager or from her iPhone?
I don't have an extraction from the iPhone, it was from the Voyager.
Yeah. All right. And then you read those out, and those are accurate emails indicating some contact or wanting to see somebody else.
There were no emails, it was just contact through text messages, yes.
It was text messages.
Correct.
And it was a conversation between two phones about contact.
Correct.
What you read out earlier is exact word for word.
Yes.
And one of them was about seeing or getting together.
Correct.
Along those lines. On 10/30, well, let me make sure. On David Swift's BlackBerry, I guess the calls to his wife's phone, iPhone.
So I count myself blessed, Miss Ronnie.
Generally.
I believe that's correct.
And they continue through that afternoon.
There were a couple, I believe, yes.
You read them out earlier, correct?
Correct.
He also has conversations, either receives calls from others that afternoon of 10:30.
Correct.
Or
made calls.
Yeah, and they indicate trying to locate his wife.
I don't know what they indicated.
I mean,
I don't know what the conversation was. I just know that.
Yeah, I'm sorry. They weren't text messages, they were phone calls.
Well, that's what you asked me. They were phone calls.
Yeah, you can just tell who he called.
Correct.
You can't, there's no text messages to others.
There are some text messages, but I don't know in reference to who they are in reference to him.
And if these witnesses have testified previously that they either had contact with David Swift or called him, that might explain some of them.
It could. I don't have any knowledge of that.
Just 1 second, I'm almost finished. Now, in order to download photos from an iPhone, would you need a password? Or
not necessarily.
Would you need a user ID?
For the computer, in this case, you would not necessarily need one because it was not on the gateway, it was on the Dell Dimension.
Right, but if I'm downloading something from my phone, do I have to plug it into the computer?
You got to plug it in, but there may or may not be that ability or that requirement to unlock the device or to have a login password.
But if the iPhone was used to download, and I guess every so often, do you have to, like if you don't use your phone, you have to do something to gain access to it?
You have to put in the password if it's set, but I didn't examine the iPhone.
I know.
So I have no idea whether it had a password.
Whether it did or did not.
Correct.
And if there's been testimony that Karen Swift changed her password or username all the time, it's possible there could have been a username or password.
It's possible. I don't have any knowledge of that.
And you're saying the Voyager phone was not password protected?
It was not password protected. It did have a user code, which is for the operating system is pretty default, the last 4 of the phone number.
So on the iPhone, really, you mentioned about the state of it, Karen Swift's phone. that you just have the backup of the iPhone? Is it possible that that is all you have to indicate whether or not she did or did not save pictures or download pictures?
That's the only time that on that device, that desktop, right, that Della mentioned, that she backed up. If there was previous backups or backups after 1018, they would have been there. Or they could have been deleted, right? So that option is there as well. But there's no indication that there was any other iTunes backups of that particular iPhone outside of 1018 on the Della mentioned. Every other.
Why is Proctor not testifying for the prosecution is what I want to know. Why is he not?
Backed up version. That's not, and the person who doesn't back up their phone, they go 2 or 3 weeks and there's activity like taking photos or deleting photos or downloading
I
photos.
don't understand that.
Unless you can access it, you wouldn't, and had the correct device, you wouldn't be able to tell whether they downloaded it or backed it up.
If he fought to believe that they
You
were
can back up
guilty,
your phone in a variety of ways. You can back it up to.
he
the computer
believes
in
she's
this instance, or
guilty.
You can back it up to the cloud. I don't have any knowledge of that. There again, I've never backed up a phone, so when it fills up, it just fills up. But people back up their phones quite frequently, and there's no rhyme or reason as to why they back them up. They may back them up so that they can get a new phone. They may back them up because there's an update coming out. They don't want to lose the content that was there in case the update messes up. So there could be a variety of reasons why that backup was on that computer. I can't answer you why there's not any more backups. All I know is when I got the iPhone, it was not in a condition to be analyzed for input.
And if things have been saved to a cloud, you didn't have access to that.
I did not, no, sir.
Thanks.
not unless you give him access.
Not the 7:30 to 8:30 activity, but you said that the gateway, you were able to log on at around 2:45 in the morning, I believe so, and stayed on until about 3:30 when we saw this scrolling.
Correct.
Okay, does that mean that, when you say that user was logged on during that time, does that mean they were actively at the computer pushing keys?
Those files were actively accessed during that time frame, so they had to have, whoever was behind the computer had to have some involvement to view those files.
Okay, but I mean, if I logged in at 2:45 as user 10, and then I had to go to the bathroom, and then I come back, am I still logged on?
You're still logged on.
Just one more question.
Yep.
You log on, you're saying they're showing that the person did some activity. They just didn't plug their phone in. They did some activity like scroll through or look at photos.
There was a external device. I can't tell you whether or not it was the phone at one point or another. We do see in the proceeds with the USB evidence that was presented that a Kingston data traveler USB device was plugged in. Because of the way that digital camera folder structures name their folders, I'm not able to determine whether or not that digital camera was a phone or a USB device that had copied those files from the digital camera.
Right, but I'm saying the ones that you went through all the pictures at the times, you're saying that that wasn't an automatic thing. There had to be somebody
Correct. They are, as the pictures load and they're scrolling down, that's why we see the variation in timestamps, because it's taking that thumbnail snapshot of the original image and displaying it in the file view.
So there was activity that indicates that the person was using that device.
Correct.
The person wasn't gone or just simply plugging it up and gone elsewhere.
No, they were actively on the device at that time.
One more thing, and I'll sit down. Did you examine the camera?
I examined several cameras.
Can you can't say which device the download of the photos came from, or?
This one appears to be a Kodak Easy Share, but there was not, the same SD card was not found with the camera at the time of the examination.
Sir, you can step in. Thank you. Call your next witness, please.
Non-state race.
What did they say?
Things we had to take care of without the meeting, so we'll go ahead and take our lunch break just slightly early. I said lunch will be 10 minutes. 10 minutes, mark it down. Now, while you're lunch, do not discuss the case.
Okay, guys, while they take a 10-minute.
Please continue.
Oh. I am so needing to visit something.
iTunes backups.
I guess if you just have the backed up version, that's not, and the person doesn't back up their phone, they go 2 or 3 weeks and there's activity like taking photos or deleting photos.
I didn't back up too far, did I?
Unless you can access it, you wouldn't, and have the correct device, you wouldn't be able to tell whether they downloaded it or backed it up or not.
Well, you can back up your phone in a variety of ways. You can back it up to the
Oh, I did.
moment.
It's whether the state has produced it.
Of course, I listen to and ask questions of the witnesses. Sometimes we hear things differently. Blood
incident where Miss Swift about the screw, and that there, if she was going to be on the computer also, she wouldn't get her husband's computer, who testimony showed he changed the password a few days after the divorce, which indicates he didn't want Miss Swift to be able to get into the computer. Also, if you was, on the photos that were shown, there was a computer in her room, a desktop. If she wanted to use a computer, there was already one right there in the room. Your Honor, there was testimony about the screw being placed in the tire. You heard that testimony that was intentionally done. It was manually inserted into the tire. You also heard proof about that screw that when it went into the tire, it sealed the tire. So the purpose of putting the screw in was so that it would go flat. But the testimony was it sealed the tire, so the tire had to be manually deflated. Now, the proof was that Ms. Swift's cell phone left the house at 4:38 a.m. And we know that because the cell phone disconnected from the network extender. We had proof from Mary McCorders that at 4:40 a.m., 2 minutes later, she hears a car coming down the road with a flat tire. And that noise stops when it gets to the intersection of Harness and Millfield, where Ms. Swift's car was found. We also heard proof from the expert on the tires that there was run flat damage on that tire. He indicated that run flat damage would have been done in less than a mile. Ms. Swift's house was a quarter of a mile from where the car was found. Your Honor, in addition to that, he talked about the screw and that there would have been more wear on the screw had the tire been driven for a long period of time. At 5:04, the phone pings, and you heard from Carla Rexing with the FBI that there was a mark of where the phone could have been. And the ping, one of the things that the Sheriff's Department thought was that it was by the Mississippi River. She showed that on that arc that it was more likely he was in the what she called the area of interest, which was the house and where the car was found. But we also got on proof that where that ping was, if it was by the river, was a round trip drive of 41 minutes. And it does not fit within the timeline that we have for a person to be able to drive there and back with a phone. Because we know that because she also said that the phone was moving. At 5:04, the phone started moving. But she said it was moving at a pace of a person who was walking with the phone. And she said if the person was driving, it would hit more towers and different towers. And because it stayed on that same tower, it indicated the person was walking with the phone. At 5:09, the phone stops working. And we submitted that as the time that the phone was destroyed. The phone was stomped at that time and it stopped receiving data. In addition, when Officer Alexander arrived on the scene, he testified that the car was locked. The bonus testified that they were the first ones to get there and the car was locked. Officer Alexander had to get Mr. Swift to go home, get the spare key and come back and unlock the door. He testified that when he got in that vehicle, the seat was in the position that was all the way back. Ms. Swift was a small person and it would be impossible for her to drive that car with that seat all the way back. The seat would have to be in a forward position for her to reach the pedals. The defendant claimed that he had a knee injury, and that's a big part of this case because he claims that happened on October 25th, which was right before the incident where Ms. Swift became missing and was murdered. You know, that's very important because that shows his premeditation. He started planning this several days before. So he had to claim he had a knee injury so that he would not be physically able to commit a murder. We put on ample proof, Your Honor, that that was not true. We put on proof of individuals who saw him the day before this happened, who was walking without crutches. He was climbing on and off of a four-wheeler without any use of crutches, without any problems with his knee. And the day of the Halloween party, Mr. Swift actually takes that hay back, climbs up in a trailer, gets 65-pound hay bales, and either drags or hands those to Mr. Harris to help load those. A person with an injury to his knee so severe that he had to have crutches, it would be impossible to climb on a trailer and move the hay bales in that manner. In addition to that, you heard from Gary Smith.
True.
And he told you that the defendant did have the strength and the range of motion that was needed to drag a body 20 feet from where the car would have stopped and where the body was found. Your Honor, also, the defendant admitted that he did clean the garage with blood with a bleach. He told the officers that he did that because there was vomit from a dog in the garage. So he used bleach to clean that up. Your Honor, the state submits that that was also a part of what happened that night. If you'll recall, the DI agents had testified when they went and did the search of the garage that they received presumptive positive tests of blood in that garage. And they stated that when they took it back to the lab and did further testing, it did not show the presence of human blood. However, he testified more than once that something caused that to be positive. He also stated, when asked, that bleach could cause that to happen. That bleach is one of the best tools for cleaning up blood, and that it could have caused the blood to not be in the same condition that it typically would be when it was tested at the lab. You heard from the medical examiner. He talked about the injury. He talked about the possibility that he didn't know what could have happened as far as whether she may have been strangled. He could not say that she was or she was not because the hyoid bone was missing, as well as the thyroid cartilage. He did say that the fatal injury, regardless of whether she was strangled, was the wound to the head. That it definitely by itself could have been the fatal injury. He said that this was the type of injury that could have caused little or no blood. He said it could have been a closed head wound injury. He also said that if the person was strangled and the injury to the head happened afterwards, that there would be little to no blood because the heart was no longer pumping. So there are more than one explanations of why there may not have been a large amount of blood in that garage. Your Honor, the state believes that based on all this, we have given more than enough proof for this to be a decision for the jury to make, and we would ask that you deny the motion.
Mr. Goodman, does the state acknowledge that the state's case primarily, if not totally, circumstantial?
Yes, sir, it is.
Thank you. Anything else you want to add, Mr. Taylor, to your motion?
You're asking a few more things. Regarding the issue of the blood in the garage, of course, I listen to and ask questions of the witnesses. Sometimes we hear things differently. Blood is used to clean up at the lab. I recall the witness testifying.
Bleach?
Excuse me. Bleach is used to clean up blood. They don't go together, and it could affect the results of the test. So bleach either eliminates blood, or it would test positive for blood, but fail to show any other results, I believe is what I understood. In this case, the swabbing of both walls and the floor of the garage indicate the presence is blood not of human origin. That means it's not a human. They can't tell if it's a dog or a cat, but it's not a human. They do have a result. It's not human. So if it's not human blood, if he's cleaned up the garage, it makes sense based on what the witness said that they can show the presence of blood, but it's so degraded the sample that they can't tell anything else. They can in this case. It's not human. That means I infer it's animal blood. They can't say what type of animal. We belabored the smell of bleach and all that, which is nobody indicate that in the car, in the garage. To say that my client, I guess the state's arguing that they're basing this plan of premeditation on my client allegedly faking an injury of himself and then staging it to make it look like he's injured so he knows he's going to kill her. We do, just from what we have right now, you just heard the state's proof. You hadn't heard anything else. We do have Dr. Smith, not Dr. Smith, but Kerry Smith, I think this is his name. He was pretty animated, but he indicated that he doesn't believe that my client, he did have an injury. He did also get the referral from a doctor that my client saw before he saw Mr. Smith. And it
Y'all, I was attacked by a pit bull. Wasn't the dog's fault. It was the owner's fault. The son told me that the dog would kill me, and then he let go of the leash, and the dog tried to kill me. I tore the ACL, the MCL, the LCL, and I tore everything that attached to my kneecap and to my knee. And let me tell you, if you're having knee trouble, and I still sometimes struggle, sometimes I want to be on my crutches, but there is no way in snowball chances of hell I've been on after 2 hours that I would even be throwing bales of hay today on my best day, even if I had surgery. Because let me tell you something. Once you screw up your knee, it is never the same. And I don't care how good you're feeling on that day. You throwing hay bales, is going to risk destroying your surgery. And you had to have a second surgery. So I call bullshit. I said it. I call bullshit.
indicated he had an injury that was serious enough that it affected his ability to get around. And so we got a doctor referring him to a physical therapist. The physical therapist asking what he thinks in his own mind he can do or not do. And the therapist puts him on a treadmill and he's holding on to the sides and he's trying to walk to show him. He indicated my client was trying to push himself to show that he was trying to get through it because he had work responsibilities and family responsibilities. There are numerous witnesses that saw my client with crutches and also that saw him with a leg immobilizer. You can see it on the tape when he goes and talks to the police. I guess the state suggested my client.
I will say there are times due to rheumatoid arthritis flare-ups that I have to be in crutches or wheelchair. But I will tell you, snowball's chances in Haiti with the next day. If I'm on crutches one day, I am not going to be baling hay on the next. Country Girl has baled hay. Country Girl has, those bales of hay are 65 pounds each. And you pick it up and you twist. Even if somebody else is doing the lifting. I don't want to hear this wham wham.
I staged the whole thing so he could commit
Oh,
the
and
murder.
not human blood?
And even though Karen Swift intended on being at the
Chicken
Douglas
blood?
house that night and not coming back, and we're not clear because Karen would sometimes go and not let him know where she's going, or sometimes she would. She comes back unexpectedly, and he's planning all this so that with a leg injury, so he could just get his hands around her and kill her on that occasion. It didn't make any sense.
You're trying. You are
As far
doing
as
your
inconsistent
job, and you're
statements,
doing a good job at it.
journalist, this is
But
a
I'm
case from
not believing it.
2011. They relied upon questions of witnesses for the state and of my client interviews. Hey, the newscaster called him while he was at lunch and asked him a few questions. The newscaster couldn't remember. Well, I think he said, but I'm not really sure. You go off what you remember, Your Honor, that the newscaster that was writing the book and others. I don't know. It's just sometimes people, as a lot of the state's witnesses, when they came in here, they testified for the state. And you recall how I had to drag things out of them by use of a transcript that were different or explain fully the circumstances. People over time get things mixed up. Does that mean they committed first-degree murder? It doesn't not. The proof is insufficient. And I submit it to Your Honor.
So what is he doing? Asking for a dismissal?
Today as part of the reason for premeditation. Another thing is, if you will recall, more than one witness testified that Mr. Swift attempted to go to dinner that night with Ms. Swift. He wanted to talk about the divorce. She refused. She told him it was over, that there was nothing else that could be done, and she was going to the party rather than doing that. You also heard testimony from Janie Helm that he was furious about that. You know, also, it could be that that was the moment that he put this plan into motion.
I'm confused what you're trying to do,
The state
dude.
acknowledges that its case against the defendant is primarily, if not purely, circumstantial. In the face of a motion for judgment of acquittal, the question for the court to determine at this moment is whether the state has produced sufficient evidence to permit the case to go to the jury. That is, could a reasonable trier of fact find guilt based only on the state's case in chief. The state's case here is circumstantial, but the law does not require a judgment of acquittal when the evidence presented is purely circumstantial. A case that is purely circumstantial is different in that there is not always the direct proof that we have in other cases. And there are a couple of older cases that deal with the criminal case being circumstantial evidence. There's a 1918 case, Webb versus State. Issue presented is whether the trial judge had committed an error by failing to instruct the jury on circumstantial evidence. The Supreme Court acknowledged that the case against the defendant was purely circumstantial. The trial court permitted the case to go to the jury. The Supreme Court reversed the conviction, not because the trial court let the case go to the jury, but because the trial court had failed to instruct the jury on the law of circumstantial evidence, that is, how to weigh circumstantial evidence. The additional case is Bishop versus State, 1956, Tennessee Supreme Court case. And again, like Webb, the state's case at this trial was purely circumstantial evidence. And again, the Supreme Court reversed. And also, not because the state's case was purely circumstantial, but because, again, the trial court had failed to instruct the jury on circumstantial evidence. There. In the court's view, there is sufficient circumstantial evidence to submit this matter to the jury for determination. So the motion for judgment of acquittal will be denied.
Yay!
Has Mr. Swift made a determination whether he wants to testify or not? We're not ready to announce this time. Okay, can we go ahead and let's have our moment of inquiry, at least so that he understands on the record what his options are.
So he's not going to testify. Shocker.
Yes.
Mr. Swift, can you hear me? Yes. Can the record hear me? You have the right, you're the defendant in this case. You understand that it is your choice, along with my advice, as to whether you want to testify during our proof. The state has rested. They have presented their case. We will start our case in just a little while after lunch. There will be several witnesses. You understand that you have the right to decide whether you want to testify or not testify. Yes. And you understand that that's solely your decision with my advice, and that we've consulted about it. Correct. And you always have the right to do that if you want to get on the witness stand. You also have the right, since the state has a burden of proof, you don't have to testify. No bad things can be inferred by the jury from that. Do you understand that? Correct. Now, do you agree to keep your mind open and continue to discuss with me through your state's witnesses, through the defense witnesses, whether you want to testify
Yeah, I
or not
know.
testify, and at some point will be required to make a statement about whether we're going
I must have been in the little girl's room when I left when I heard that the state had rested. I didn't hear that.
As far as the time,
That's a
we're
good
gonna
girl.
kick off our proof when we come back, and I intend on having it lined up so it can be orderly. Would you give us, are you saying we're gonna come back at, would you give us to
One,
1:30?
I was thinking, do you need more than that?
Would you give us to 1:30, Judge? I promise.
Okay, we're going to do that. Guys, we don't have a whole lot longer. I'm willing to continue, or do you want to go on tomorrow? We still have a decent following. But what I want to say is tomorrow we can watch his case if it's on. But I will have to do it probably either afternoon or morning. I'm going to have to take off half a day because I've got to get some lab works and stuff done before my doctor's appointment. So I'm going to keep going if y'all want to hang in. I really want to catch up. So that way, when they go to court tomorrow, we can come in tomorrow and watch it. I'd love to see them go to trial tomorrow. And of course, there's no sound. No, they're kind of just joshing around. Okay, here we go. We had the wheel again, so let me see when I need to leave for my appointments tomorrow, and then I'll let you know when I'm going to go live.
All right, let's see. Y'all sure you're in the right seat now? I think for anybody to get out of here. Tell me how everybody feels. Yes. You good? Okay, very good. Come on, first witness. The owner of the defense calls Robin Alford. Ma'am, would you introduce yourself say your name?
Yes, my name is Robin Alford, Alford.
Thank you, ma'am. Let me ask you a few questions. Back in 2010, did you know Karen and David Swift?
I did.
Would you just briefly tell me how you met both of them?
Yes, Karen and I's relationship started off with the connection between our daughters. Her youngest daughter, Keely, and my daughter, Allie, just had a sweet friendship. And so through that connection, Karen and I started doing play dates together and just eventually being together pretty much every day or every other day.
And did you live in close proximity to the Swifts?
Well, we both lived in Dyersburg. I would say 10, 12 minutes apart.
Did there come a time back in 2010 that you and your husband and David and Karen Swift started doing things socially?
Well, Karen and I's relationship was always family oriented. Everything we did, it was with the kids. We were both stay-at-home moms, and she was a wonderful mother, and we did so many things together. There was multiple times my husband and I would be around Karen and David and witness it to be a good marriage.
Did you do family activities with the Swift family, you and your family?
Yes, we would go to my dad's farm. We'd go fishing. We would have bonfires. We'd ride four-wheelers. We would take them to water parks. We were on the go all the time. It was so much fun.
Is there a time?
Just had a sweet friendship. And so through that connection, Karen and I started doing play dates together and just eventually being together pretty much every day or every other day.
And did you live in close proximity to the Swifts or?
Well, we both lived in Dyersburg. I would say 10, 12 minutes apart.
Did there come a time back in 2010 that you and your husband and David and Karen Swift started doing things socially?
Well, Karen and I's relationship was always family oriented. Everything we did, it was with the kids. We were both stay-at-home moms, and she was a wonderful mother, and we did so many things together. There was multiple times my husband and I would be around Karen and David and witness it to be a good marriage.
Did you Did you do family activities with the Swift family, you and your family?
Yes, we would go to my dad's farm. We'd go fishing. We would have bonfires. We'd ride four-wheelers. We would take them to water parks. We were on the go all the time. It was so much fun.
It was like a frat party with children all the time.
Relationship sort of changed.
I could see that Karen was kind of drifting away from her marriage, and she
Oh,
was speaking in
geez.
confidence about not being happy. There was a little shift in her priorities, and so our friendship kind of suffered from that.
Okay. Was there an occasion that, did you know the Bonas?
Yes.
All right. And can I ask how you knew them?
Kathy was our daughter's dance instructor, and she was also the YMCA fitness person there that we'd go to classes together there. Karen and I's relationship, we were friends way before kind of Kathy came into the picture, but then we would have swim dates and stuff like that. I was invited to go to Kathy's 40th birthday party. My husband didn't want to go. He wasn't a big fan, so I went with Karen that night. We had a good time.
Did you and Karen drive together, or was there a lot of people there?
She came to my house and we got ready. We took pictures before. I think we drove separately to the actual venue.
All right. I don't want to go into every detail, but did you attend the Bona's 40th anniversary party?
It was her 40th birthday.
40th birthday party,
Yes.
excuse me. And were there several people there?
At the farms, at the venue, yes, there was.
And after, it was a eat and drink event at the venue.
Yeah, just like a DJ and just a social gathering.
Afterwards, did you and others go to a different location with the Bonas?
Yeah, that would be their house.
Had you been to their house before?
No.
I know it is misspelt, but that's the only way
To the Bona house?
Yeah, I went. Karen asked me to go, and
it would
you know,
accept
it. Was
it.
a fun night, so I thought
That's it.
We'll
I'm
just
going to
see,
try and get
you
it
know,
changed.
where the night will take us.
But right now, that's all I
Was there a
got.
hot tub involved?
There is outside on their deck. They have a hot tub, and it's not the main focus of the backyard. They have a pretty large deck, and there were several tables, several people engaging in conversation. I would be sitting at a table with other people having conversation, but to the left of me, I saw the hot tub, and I saw people get in the hot tub.
Were people in different stages of dress or undress?
Yes.
All right. Was it primarily in the hot tub?
Mm-hmm.
Uh-huh.
It was, yes, the hot tub. There were people that maybe didn't have bathing suits and got in their undergarments.
And I just want to get through this very quickly, but did you see Karen Swift leave the hot tub and go into the house?
I did. I witnessed her get up. She looked to me as if she was hot and woozy kind of feeling. And I saw her go inside. And it wasn't but a few minutes later, I saw Mr. Bona go in as well.
Can I ask this? Was Miss Swift, was she wearing her outfit, or?
That's vaguely something I'm trying to remember. I know when I walked in and I witnessed her laying on the floor, she didn't have anything on her.
All right. Now, she walked, are you saying that you saw Karen Swift walk from the hot tub into the Bona's house?
Mm-hmm.
Okay, is that correct?
That is correct.
And I'm not trying to beat up on you if you'll say yes or no or answer. And after Karen Swift walked in, did you see someone else immediately walk in?
Yes, it was shortly after was Mr. Bill Bona.
All right. And then as a result, what did you do?
I walked in, I said, "What's going on?" And I got a towel and immediately covered her up. And I said, "Go get her husband right now."
Well, when you walked in, what did you see?
I saw him standing over her, gawking with a creepy look on his face.
Was she clothed, or did she have a towel on her?
I put a towel on her.
Did you see Mr. Bona put a towel and cover her before you walked in?
No.
All right. And did you make some remark, and then how did they react to it?
He just looked very surprised at me, and I was just kind of offended by what I witnessed and covered it up immediately and said, "Go get her husband, please."
And did you see Mrs. Bona in the room at that time, or next in the house at
Nobody
that time?
was in the house. I vividly remember that.
Was Miss Bona, was she near the hot tub when you walked in the house, or do you recall?
She was outside engaged in conversation.
Okay. And after you made that comment about go get David Swift, where was David Swift, to your knowledge, before you walked into the house?
He was outside at a table, just, trying to fit in, I think, and have conversation with people.
And what happened next? Did someone walk into the house? Did you stay first off with Karen Swift?
Until David come in, yes.
Was Karen Swift, did she act like she was either ill or under the influence? Or?
I said, "Karen, are you okay?"
and she's just kind of coming out of a, you know, a state of kind of what's going on. And she said, yes, I'm fine. I said, David's coming to get you and you're going home.
Okay. And then what happened next?
From what I recall, David picked her up, got her belongings. Maybe I carried her to the bathroom and got herself together, I would think, before she went home. But I know that I walked out with them and never returned.
Okay. And to your knowledge, did the Swifts leave either before you or at the same time as you did?
I would say at the same time.
Right. Now, after that, did you ever go back to the Bonas?
No.
All right. Did you have a conversation with David Swift after that about this incident?
David would ask me things, and I think one time he did ask me. I, of course, talked to Karen the next day, and I just said, again, is everything okay? Did, you know, anything happen last night? And she, of course, you know, told me it's fine, and no, it's everything's okay, Robin. And I said, well, you know, you can always let me know if you need to tell me anything. And she said, I will.
Did she indicate that it made her uncomfortable or if she felt like she was being threatened?
I told her that she needed to tell her friend Kathy.
After that, did you talk to Kathy Bona about this?
They never once approached me at all and never asked me what I saw. I know that it got back word to her because she immediately wanted to give me a brushed off feeling. But
You talked about the next time you saw her, you didn't communicate with each other?
No, like I said, my daughter still went to her dance studio. And I mean, was it awkward? Yes, but I'm going to call out some misconduct if I see it.
Well, and I just want to go off what you saw or what you observed, not what you think others did,
Yes.
just to be fair. But after that, did you and Karen Swift have communication and get together sometimes?
Like I said, Karen and I always revolved around family. I even got to see her with her 2 older boys, not just her 2 younger girls. I mean, she was a wonderful mom to all 4 of those kids. And I saw a shift in her marriage, and I saw that it was different. Her priorities changed. She would be going out after the kids would go to sleep, and that's not what I wanted to do. And so therefore, our friendship did take a step back. I was always there for her. She called me on the phone. She texted me. But it kind of, we didn't hang out as much.
Okay. And I guess, did you talk to her, if she went missing, she did go missing on October the 30th of 2011.
Mm-hmm.
Did you have communication with her shortly before that?
I was in Nashville that weekend. I was going to attend a Titans game on Sunday, but I know that she called me Friday night, and she said, just to let you know, the girls and I went and rode your house tonight. Don't be mad, please. We can come and clean it up the next day. And we had a good laugh about that, and that was the last time I spoke with her.
Did you, were you aware whether or not, when you first met the Swifts, that they drank alcohol or not?
Karen never drank before she came to Dyersburg, never. And I don't think that she could handle her alcohol at all, not well, at least. You know, it would be just a small amount, and it would give her a different feeling because she didn't have a tolerance for it.
And to your knowledge, while you're with the Swifts socially, what about David Swift drinking?
He never drank. He may hold a beer, and that beer would last all night.
Okay. And at some point, did you tell David Swift what you observed on the party?
I did. And then it got back to Karen, and that's okay because I stated my truth and I saw what I saw.
Okay. Just a second.
Don't know if I like her as a witness.
To your knowledge, I guess in 2011, did you see David Swift with an injury or on crutches?
I did. He brought the girls to me on Halloween of 2011.
Yo, I'm going to
That's
probably end it
she was
after
missing
this
on the 30th.
witness.
And I took the girls trick-or-treating that night, and he dropped them off because he couldn't get around the neighborhood like we did.
Tired.
And he came back around 10 o'clock that night and picked them up again.
So that was you had contact with David Swift on the night of October the 30th.
Halloween, yes.
And I guess, was it solely for the purpose of you taking the girls so they can
Right.
enjoy Halloween?
Just to give them some normalcy, because they asked multiple times that night where their mom was. And we just tried to make it as normal as possible and as fun as possible, which was a very hard task, but we did what we could do.
And he brought them and dropped them off himself.
Yes, he had their costumes, and then I kind of put it together, put their makeup on, and, you know, got the rest of them together. But he did. He dropped them off, and he was on crutches.
Thank you, ma'am.
Y'all, I don't know what to think about her.
My name's Danny Goodman. I'm with the district attorney's office. Ma'am, what did you tell David you saw that night at the hot tub party?
I just told him what I witnessed as far as walking in and seeing Mr. Bona standing over her, gawking somewhat.
Did you tell him that you thought that Mr. Bona was taking advantage of Ms. Swift?
I don't recall those exact words. I just know it was awkward, weird, and creepy.
Okay. Do you remember giving an interview on October 31st, which was the day after Ms. Swift went missing to the sheriff's department?
Yes,
Okay. Do you remember telling them about that incident?
I would tell them about that, yes.
Okay. And you just testified a few minutes ago that she was laying on the floor when she went in.
There was like a pillow, kind of floor pillow, and that's what I saw or what I remember her laying on. It could be a couch cushion, I don't know. It was just something in the floor.
Okay. And you stated that you went and got a towel and put it over Ms. Swift?
I had a towel when I walked in.
You're the one that placed that over Ms. Swift?
Yes.
Okay. Would you be surprised that in your statement the day after Ms. Swift went missing, that you gave a different statement to the officers?
I'd like to see that.
Okay, I'm glad to hand it to you. Let me mark the portion for you.
Y'all, I don't trust her.
Okay.
Is she married?
If you will look at the last paragraph, it's highlighted. I put a star beside it. Would you read that? Wait a minute, Jim. I'm sorry. That's a statement that you have.
I'm going to go ahead and end it after her, y'all, because I've been doing this for more than 10 hours today, and I am fading, and I got to be up here in the morning. So I'll be up here at 9 o'clock, and we'll go off in the afternoon.
Did you read it?
Just read it to yourself.
So I'll be back here about 9 o'clock. And then tomorrow afternoon, I'll take off and do what I got to do.
Did you read that?
I read it.
Okay.
Yes.
Does that refresh your memory?
I talk about a towel.
Okay. And you actually say that Bill put the towel on Miss Swift.
There was standing there with the towel. Alfred saw a towel on Karen. Maybe I handed Bill the towel and said, cover her
Okay,
up.
but that actually says when you came in, you saw a towel on Karen. Is that what that says?
That is not what I recall. And
Is that what the statement says?
that says Karen told Alfred that Bill put the towel on her.
Did it also say that you saw a towel on Karen when you walked in?
It says Bill was standing there and Alfred saw a towel on Karen.
Okay, so if
But
you
it
saw a
does not say
towel on
that I
Karen,
said that.
Just a minute, one at a time. He's asking the question.
so if you saw a towel on Karen, you couldn't have placed the towel on Karen, could you?
Either I or I gave it to Bill to put a towel on Karen. But when I walked in, there was no towel on Karen whatsoever.
Why did you tell the officers it was?
From what I remember, that's not what I said.
Could you hand the statement back?
I'm not believing her. I don't believe her.
You also questioned Karen about it the next day, didn't you?
I did, yes.
And Karen
Sorry,
told you
not
nothing
sorry.
happened, Didn't she?
She did.
Okay. And you also told the officers that Karen was coherent that night.
She looked up to me after I walked in and said, "What's going on?"
Okay. Did you tell officers she was coherent at that time?
I'm thinking she was coherent, but that would be me assuming because I don't know what her state of mind was at that time, but she did look at me once I walked into the room.
Okay. Well, obviously you thought you knew her state of mind the next day because you want to look at the statement.
I believe I remember saying she was coherent because she
Okay.
looked at me in the eyes.
Okay. So if she was coherent and the next day you talked to her about it
Yes.
and she told you nothing happened,
She did.
do you have a reason to doubt her then?
No, I don't.
Okay.
And why did you run to her husband and everybody and try and stir the freaking pot?
Now, David is the one that actually told you that Bill was trying to make a move on Karen, isn't
I think he may have asked me that one time.
he? Did
Mutt?
he tell you that Bill was doing that?
Did he tell me personally
Yes.
that Bill, not that I recall.
Okay, would you look at the
It could be
statement?
in my statement that maybe he asked or,
Okay, would you
So
look
if
at the
I have
statement just
that-
to refresh your memory again?
yes, sir.
Okay,
Quit.
It is the third paragraph. If you will look to the
Shut your
left.
mouth
it's the first
and
part.
listen to what he is asking you. You know you got your hand caught in the
Have you read
cookie
that?
jar.
Okay, it's only one sentence.
It's okay.
All right, let's just
Does that
admit
refresh
it.
your memory?
That didn't happen.
It says David said that, yes.
Okay, so that actually says David is the one that told you that Bill was making a move, right?
But that's not what I recall. because
All right,
that's
let's just
why there
admit
was
it.
an issue
That didn't
with
happen.
Our friendship is because they disengaged from me because of what I said or what I walked into and that I questioned it.
Okay. Well, how would David be able to tell you that Bill was making a move if he wasn't even in the room?
He wasn't in the room.
How would he be able to tell you that then?
He'd asked me about it, and if that's, he didn't tell me anything unless if he knew of another time. I don't know. That was just what I recall from that night.
And you knew that Karen was going to get a divorce, didn't you?
She texted me around the middle of October, and she said that she had filed for divorce, and my response was, wow, that's a big step.
Okay. And then David was always controlling of Karen, wasn't he?
He was.
Okay. And he was always curious about where she was and what she was doing.
He was.
Okay. And he called her all the time to find out where she was. Right?
Yes.
Okay. Would you agree that Karen really never had a life when she was with David?
Yes. I know when they lived in Arkansas, she was just a devoted mother. She didn't have many friends. And I saw as she moved to Dyersburg and we became friends and how her circle of friends grew and grew. And she loved that. Karen loved to go and do and be center of attention sometimes. She liked to always have friends, and she wanted to do something with someone every day.
And David didn't want her to do that, did he?
I don't think if he wasn't involved, maybe not.
Okay. Would you agree that David Swift is good at mind games? Your Honor, I'm asking about her statement.
Repeat the question.
Would you agree that David Swift is good at mind games?
I will agree that I said that he is, that she told me he was good at manipulating situations.
I guess the objection was overruled, since you went ahead.
I'm sorry, sir.
You made a statement when you were testifying previously that Karen would leave the kids at night if they went to sleep and go out.
Yes.
Did you see that?
I have, yes, there would be times where she would stop by my house, occasions when she was out or
At what time?
doing, it could have been 9 o'clock, it could have been 10 o'clock, but nothing later than that.
It's not extremely late.
No,
But she never left the kids alone.
no, never.
And you said that Karen could not handle her alcohol. Is that right?
From what I witnessed, she wasn't a big drinker, but when she would, she wouldn't be able to tolerate it very much.
Okay, so if she had been drinking on the night that she came up missing, do you think that she would get out after going home?
Hang on a second.
I'm not gonna say.
We're good now, all right?
Yes, sir.
What's the objection? No, what's the objection? I court agrees that the objection will be sustained. Let's move on.
Okay, you also said that you saw Mr. Swift on crutches. Is that right? Okay, and you said that was on Halloween when he brought the girls over. Is that
Yes,
correct?
yes.
That was on October 31st of 2011.
Correct.
And Karen was already missing at that point.
Yes,
You didn't see Mr. Swift before that on crutches, did you?
I know, I didn't.
Thank you.
Redirect.
The prosecutor asked you about the statement that he passed to you.
Mhm,
He asked you questions about that.
He did.
Did you sit for a video interview with the officers?
I did sit for a video, yes.
All right. And did you answer what the prosecutor showed you? Would it be fair to say that that was a brief summary of that video?
Exactly what I was looking at was different from the video. I mean, it was looking more like a summary, like someone had typed up.
You weren't asked to sign that as a statement, were you? That what he passed up to you?
No, sir.
All right.
I'm going to object. These are the same statements and the same type of presented by the defense.
I think it's fair redirect.
Yes, sir.
Go ahead.
And in fact, to prepare for today, did you listen to the audio tape that was involved in this case?
I did, and I read my transcript too.
And was the summary that the prosecutor passed you a lot shorter than what you had?
It seemed summarized, yes. Summarized, yes.
All right. But you're testifying about what you recall and you're trying to be as honest as you
As
can.
honest as can be, yes.
All right. Now, when you saw I guess if Karen Swift came over to visit you in the evenings sometimes, she would surprise you or call ahead of time.
She would call on her way usually.
And you don't know where the children weren't with her, were they?
Not some nights she'd already given them a bath and put them in the bed.
And so somebody else, either David Swift or she left them by themselves. You don't know, but the kids weren't with her. So either David was watching them or she didn't have the kids with her.
Correct.
Let's put it that way.
I'm just being silly, and I just didn't want you to hear the words I was saying because they were very
No,
nice.
sir. And I would not say that.
You
she
know,
was a
your
bad
mother says if you can't say anything nice, don't say anything
You can step down if I upset you. You're good.
Thank you.
Just making it with the
She irritates the hell out of me. I really shouldn't. You didn't need to hear what I was saying. I'm tired and I'm flippant and I probably shouldn't be. Okay, so the plan for mañana is going to be we'll start probably right about 9 o'clock. That's what I'm planning on. And we'll finish this and then we will go into tomorrow's hearing after we finish this. I think we have, let's see. An hour. Right at 2 hours on this. Okay. So we'll start in the morning with this and then we'll skip through all the breaks and we'll catch up. Y'all, as always, y'all are awesome. I appreciate ya. And guess what? It's pillow time. Oh, I don't want to do that.